Good morning, all. This return date hearing is in the matter of DEC 001-2025 and is being held by way of video conferencing before His Excellency Justice Michael Black, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al Tamimi Company. Lead counsel is Mr. David Holloway. The first defendant is represented by Quinn Emanuel, and lead counsel is Mr. Tom Montague Smith, KC. Thank you, Your Honour.
Thank you very much. Mr. Holloway, you said you had about an hour more.
Your Honour, there's one issue of housekeeping that's arisen overnight, very briefly, if I may.
Yes, of course.
We've asked that 4 further documents be added to the bundle. We sent those through and have had no response. So unlike when the claimant wants to add things to the bundle and they just do it, they've refused, or at least just snubbed the invitation. The documents are firstly essentially what's happened is that the audited accounts for the fund for 2022, that audit is almost complete, and the accounts are now in their final form and have been sent to Mazars for sign-off in their final form. And we're expecting the sign-off to come through hopefully today, if not tomorrow, for the 2022 accounts. And so we wanted to introduce those. Those are brand new in the sense that that's a document that's arisen just now. The second document is an email, and it's simply a single-page email. One of the points that my learned friend made yesterday was that there was confusion as to the terms of the initial investments, that we've produced term sheets in relation to those investments with DMCC. And there's a single page of email, which is dated 18th April 2022, which shows those terms being sent to Mr. Chock at FDT. It's one pager. The other 2 documents are documents that arise in the Hong Kong proceedings. The first, we'd understood my learned friend wanted to introduce himself, which was the Chock affidavit.
I was going to ask about that. Yes.
Your Honour asked about that. We're content for it to go in. However, there is another affirmation from Hong Kong that we would ask be introduced, because obviously Mr. Chock's dealing in part with the glass door payments and the reasons why the payments were made to DMCC in the first place. And there is an affirmation from Hong Kong from Ms. Yai, who is from Glassdoor, who deals with the Glassdoor payments. Those are out there. That's been out there for a month or so. So we would ask that those be introduced. We're a bit surprised we didn't even get a response from my learned friends team, but there it is. And we don't really understand what the problem is.
Okay. Mr. Holloway, any objections to those going in?
First point is there's no objection to putting them in the bundle, and that's what I was going to say to Your Excellency just before my learned friend cut in. However, we do have reservations about adducing these documents and admitting them. And the reason that I say that is that there were 2 things that I wanted Your Excellency to look at yesterday, and I didn't refer to them, but I mentioned them. They were both from Mr. Britton himself, documents that he'd referred to in the Hong Kong proceedings, things that both parties had seen years ago, bank statements from Mr. Britton sent to us that had been, exchanged between the parties a long time ago. Everybody's seen them. And in fact, Mr. Britton had relied on some of them in Hong Kong. I didn't see there could be any objection to that, given the fact that there are documents that Mr. Britton had introduced into evidence himself. What's come in overnight, and I haven't had a chance to even read it yet, is of a completely different character. That is, it looks like it's new evidence that's been put together while I was on my feet yesterday in answer to queries that have been going on, relevant queries that have been going on for years.
Well, forgive me, the documents in relation to the Hong Kong proceedings.
Oh no, that's fine. I mean, we can admit both those affidavits. I had explained to you the simple point that I wanted you to look at from Mr. Chalk's affidavit was that he said that Mr. Britton's
Well, we'll
point
look
was
at we'll
incorrect,
look
and
we'll look at them, and we'll look at them in context too. So that's fine. So the other two documents are the accounts.
And I really haven't had time, and my team hasn't had time to consider those. So I would submit that you treat them in the same way that you treated my documents yesterday. That
well, I'm going to suggest to you what sauce for the goose is sauce for the gander. So rather than sorry to use a cliche, rather than to make no reference to the accounts, I think that you can now make reference to the documents that you didn't make reference to yesterday. So, to give you both equality, as it were, I think everything goes in, and I'll sort it out in due course. Now, you're going to say, well, I've not had an opportunity to digest the accounts. I accept that. And of course, I understand that immediately. I think it would be helpful to any further analysis on your part if you hear what, if anything, Mr. Montague-Smith has to say about those accounts. It will give you context when you ask Kroll about them in due course. So as far as I'm concerned, all in.
I'll just have to, could I suggest that we revert to yesterday's position in that you reserve judgment on whether they're in or out until you see what's being said, because particularly with the accounts, it just can't be said that we've had a fair opportunity to look at these, even if we do give off the cuff submissions.
No, I understand that. But what I mean by all in is that they can be adduced before me, and I will decide what weight to give them in the context.
Well,
that applies to all of the documents. What I'm anxious to do is what I'm anxious not to do, I should say, is exclude something which may be relevant.
Well, very well. Yes, they'll all go in the bundle. That may take a little bit of time this morning, but we'll get them in as soon as we.
Okay, and can we please do it in a separate bundle rather than adding it to the bundles that we've got? Can we also make sure that everything is in an OCR'd form? If you've never had to write a judgment, you probably don't think that's desperately important. But if you're writing a judgment, you actually have to cut and paste bits of documents. And retyping them just takes time. And the one thing you don't want in this case is delay to the judgment.
Indeed, I mean, it's the same for us writing our submissions, Your Excellency, and I've had difficulty with a lot of the documents as well, but we have tried to OCR everything that we personally have submitted, and we'll continue to do so.
Okay, well, can we just make sure that the new bundle, as far as possible, the documents are in scanned form and searchable? Well, Mr. Montague-Smith, does that make sense to you?
Yes, it makes sense. Thank you very much. As far as I'm aware, we have a PDF of those. Would it help if we simply emailed that to you? It's 89 pages once you take into account all of the pagination. I understand it looks like it is OCR'd. Obviously, we've received.
But you can just run it through Acrobat. It takes 5 minutes.
Fine. Well, what I might do is ask my solicitors to ensure that has happened. Yeah. And then would it help just to email that to you? I don't know what the best way to do is.
I think the best way to do it, since you're not literally going to be on your feet, but you are going to be on your feet later today. It would be helpful if we could have a paginated bundle so that reference could be made to it. So if it could be filed with the court, it'll automatically paginate itself, won't it, as a bundle, and then we can use it.
There's already a paginated one from my solicitors. I think it was sent over to my learned friend this morning.
Well, look, I'm not going to get involved in working out how bundles are.
No, sure.
If you could send it to us, Mr. Montague-Smith, we will put it in on the system, and if you like, we can put yesterday's together with that bundle, so everything's in one place.
I think the judges asked for a fresh bundle for this.
I want a fresh bundle of the additional documents. I want it properly paginated, which it will do if it's filed on the system, and I wanted OCR. Okay.
Here and understood.
Right.
Thank you.
With that, Mr. Holloway, do you want to continue with your submissions?
Yes. So I've got 3 bits to it, Your Excellency. First, a couple of the pleading points that Muller and Friends made on the fraud and trust case. Then I'm going to talk about full and frank disclosure, and then the relevance of the enforceability of a Hong Kong judgment. So that's the order. The pleading points won't take very long, but I do want to make them. Can I ask you to look at page 738 of the bundle, the original bundle, and that is the amended statement of claim in the Hong Kong proceedings. And I think just the point that I'm trying to make here is my learned friend says that fraud hasn't been properly pleaded in Hong Kong, and that's just not right. If I can take you to section D of that pleading and paragraph 63.
Yes, I've read that before.
Yeah, so just emphasising the last part of section 6, paragraph 63 is an express pleading that the DMCC payments were misappropriated, never made it to the fund, that the pleading is called fraud and conspiracy, and it talks about fraud, false story, and diversion. Next, so it's an express pleading of fraud in relation to the diversion of the payments to the DMCC company. Then on page 66, page 742, sorry, paragraph 66. The 6 remittances were blatant misappropriation and money laundering, and then there are a list of particulars. They were made without the knowledge or authorization of the plaintiff. There was no reason for them. Aria DMCC was held by Mr. Britton's wife, and that is, I think, particularized in terms of that limb of the fraud case. The fact that the monies were sent not where they were supposed to go.
Well, you need to read it with 67, I think.
Yes, and indeed, 67, the fund was a fraud, and the investment in the fund was a fraud, and the story that the fund was genuine was not true. So that's that is the case that we're running. The fund itself was a fraud. The story that it was a genuine fund was a fraud, and the part of that was the diversion. Connected to that is the diversion of the monies to the DMCC company. And paragraph 70, it's just sorry.
743. Yep.
Just sorry, I've missed one. Paragraph 68.5. £465 million transferred to DMCC was unauthorized and did not lead to valuable assets. So there's no basis to suggest that the case in fraud against the first respondent has not been properly pleaded and particularized in my submission. Paragraph 70, next.
Yes.
The heading is the defendants all knew and were part of it.
Mm-hmm.
And it also says that any story or representation about investing in the fund as a fund making genuine investments was fraudulent.
Sorry, where's it?
In the third line of paragraph 70.
Oh, I can see that, yes.
A story or representation investing in the fund making genuine investments for genuine returns was fraudulent, and all the defendants must have known and did know that the True Corn story was false. But there are two allegations there, and they're made against all the defendants. The one that we're concerned with is obviously the first one today. Then loss and damage, D3 at page 746. It's just not right to say that no loss or damage has been pleaded. Paragraph 76 pleads $500 million of loss and damage.
That's page 747.
747, yes. And if I can go back to 75.
Sorry, where?
75, sorry.
Sorry, where do you want to go back?
Paragraph 75, just one page up or one paragraph up.
Oh, we do want to be on 746.
746, sorry.
And we want to be in paragraph 75, not 76. Okay.
So 75, 1. The 6 remittances were made without the knowledge, approval, or authorization of the plaintiff. And then 76, 1 page down, the loss and damage has been particularized. So there's no truth in the suggestion that loss hasn't been pleaded, if that's what my learned friend's going to say. Next, on the proprietary claims, if we can move to page 751 and paragraph 86.
Yeah.
That is where the proprietary claim is pleaded against Dmcc and the fund. And then 2 paragraphs down, paragraph 88. Pleads that the fund, the claimant received no value. Mr. Britton knew that the fund's fourth defendant, Dmcc, via Mr. Britton, knew or should be taken to have known that the sums invested were directed to be paid directly to it, were being used otherwise than in accordance with the terms of the PPM. That is a pleading of knowledge on the part of Mr. Britton and Aria Dmcc that the funds had been misappropriated. And it's also a pleading that the fourth defendant acted in bad faith. So that paragraph, the idea that knowledge and notice in bad faith have not been pleaded is wrong. I should also say that the good faith purchaser for value without notice is a defence that could be pleaded by the first respondent if they were to defend the claim. But we would be able to reply to that, but we have in fact pleaded that point in advance. And then the final point, my learned friend made some noise about this at the first return date. He said that there's an inconsistency between the two cases, in relation to the authorization of Mr. De Lorraine. And I will, we've just looked at the pleading in this case, and I've shown you paragraph 66 and 68, which we say, in which we say that the DMCC payments were made without authorization, etc. And my learned friend says, well, we're saying something different in the other case, because we say that Mr. De Lorraine authorized the payments. And I just want to show you that that's wrong. And I'll point you to the pleading in the other case, just to put that point to bed, if I may. If I could ask you to look at page 8112.
Paragraph 8,
Yes,
812.
Page 812, and just before we go to the paragraphs, just to frame this, the fifth defendant in that other case is Mr. De Lorraine.
Yes.
And the paragraphs that follow this page come under the heading, the fifth defendant's breach of fiduciary duty, gross negligence and misrepresentation. And then I want you to look at what we have pleaded against Mr. De Lorraine in relation to authorization. But it comes in that section outlining what he's done wrong, rather than saying that he's done anything right. 44V is the first place I want you to look at.
44V, yeah.
That's on the same page.
Yes. Yep.
And it does say he authorized this investment, but it does also caveat by saying in breach of his fiduciary duty, etc. First of all, and that's emphasized in the next paragraph. (44W). Particularly 2, where it says the remittances were made without the knowledge, approval, or authorization of the plaintiff and in breach of the fifth defendant's fiduciary duties owed to the plaintiff. There's nothing inconsistent about the way that's pleaded in the two cases, to the extent that that's relevant at all. And just finally, these pleadings were obviously not pleaded by me. They're pleaded by Lawrence Lee, senior counsel, who's one of the most eminent lawyers in Hong Kong and a judge of the Qatari Financial Centre Regulatory Tribunal. He, no doubt, Mr. Montague thinks he could have pleaded this better, but that's not the point. These pleading points go nowhere, Your Honour. These are the Three Rivers case has been, there's absolutely clear pleading of fraud against Aria Dmcc, and even if there were anything wrong with the pleadings, that wouldn't stop you from making a freezing order if you were convinced by the evidence that you've seen here. So I'll move on from that. I'll move on to full and frank then, if I may. I realise time's pressing. And just to start this with the actual application that was made, which you'll find at page 6389. It's if we move to the full and frank part of that, which is on the second page, I believe. So it's at bottom paragraph 4. Now, this application was made on the 28th of April of this year, That's 2 months after the freezing order was made. And my learned friend said at the first return date in March that he wasn't going to make an application to discharge because he didn't have to. And he ran his arguments on that at the first return date. But then a month later, they decided they did want to make an application, and they added this on. And this is way after the hearing, and there are 2 accusations made here. The first is that I misrepresented to you that the enforcement of a Hong Kong judgment is governed by the rules of jurisdiction in Hong Kong, and that's a legal point, and I'll come to that in a second. The second is that I misrepresented facts, gave a misleading or incomplete evidence, and then he said I'll rely on the detail will be found in Mr. Britton's affidavit. So there are 2 allegations, one legal and the other factual. And Mr. Britton then in his evidence set out, I think, 9 or so allegations on the evidence, and we're trying to respond to those allegations first. My learned friend is then, Mr. Britton then served another witness statement months later, adding another 2 allegations in, and then that brought the total to 11. And then my learned friend, I think, has added 3 more, which were not in the application in his skeleton argument for the first time. But I'm going to, I'll address each one of them in turn. I think we'll start with the Tugashev case, and I think we all agree that that is the useful guidance on this, and I've cited it in the skeleton. It's at page 597 of the supplementary bundle. It's a well-known judgment, Mr. Justice Carr, as she was then. And we're looking at paragraph 7, which is a well-known sort of list of factors on page 598, going over into 599. Can you just go sorry, to the end? So there are 13 points there as to how one should view this, and you yourself, Your Excellency, I think have applied that test, or at least sort of recognised it in another DIFC case. But the ones that I want to draw your attention to here, I think we all are aware of the general framework and the duties, but number 5 first, are material facts. Those which are material, the judge dealing with the application, make the court aware of the issues that are likely to arise and possible difficulties in the claim, but not extend to a detailed analysis of every possible point which may arise. Then I'd also direct Your Excellency's attention to the next paragraph, paragraph 6, and just to the passage that there will be degrees of relevance. A due sense of proportion must be kept. Sensible limits are to be drawn, particularly in more complex and heavy cases. And then the primary question is whether in all the circumstances its effect was such as to mislead the court in any material aspect. And then the next paragraph also, I'd like to draw your attention to the first sentence. It is inappropriate to seek to set aside a freezing order for non-disclosure where proof of non-disclosure depends on proof of facts which are themselves in issue in the action. So those are the 3 parts that I would emphasize in the context of this application. And just building on that last one, I've also referred to Stephen G's commentary, and that's paragraph 9024, and it's at 1292. Now, this is in connection with the idea that
in the supplementary document.
sorry, indeed, yes, it is. This is to do with the point that we shouldn't be engaging in a mini trial. If you're being told that you should have been told fact X or fact Y, if that fact is something that's being debated and actually is contentious and in dispute in the case, that's not normally the kind of fact that is right at the end of that paragraph. I think the little sub paragraph, the last paragraph, the court will not normally hold a mini trial to decide issue, facts were disputed, or entertain allegations, proof of non-disclosure, depends on proof of facts which are themselves an issue in the action, unless the facts are truly so plain that they can be readily and summarily established. And then on the point of proportionality, again, at the paragraph of the same commentary on the next page, I believe, no, sorry, page 1298, 9024. The principle, just that first part of the paragraph, the principle should not be carried to extreme lengths. It's important that the court should consider the practical realities and not allow the principle to be used as a refuge of last resort for litigants when the substantial merits of the case and the balance of convenience strongly favour maintaining the relief that has been granted. So proportionality there. And then just as a final framing authority, we've also referred to an authority from Sir Michael Burton in the case of Darnata and Meta Bay. And again, that's a 288 of the supplementary bundle. And this is a well sort of used passage in paragraph 16. 4 lines from the bottom of that paragraph, the first part of that paragraph. And the paragraph says it shouldn't be used as a last refuge of someone tabula naufragio, planking a shipwreck. But the final sentence, in the ordinary case, the judge on the return day or on a discharge application must really have his timbers shivered by something serious that has gone wrong, rather than
sorry, where are you reading?
The final sentence from the main, the first part of that paragraph before it goes into the sub points. So it's 3 or 4 lines from the bottom of that.
Seriousness. In the ordinary case, yeah, I've got
yes,
it.
sorry, yes, Your Excellency.
Okay.
And then there's a final authority. I'm not take you to it, but it's in our skeleton. MEX group and forward. Lord Justice Coulson just says you've got to avoid a scattergun approach to this and concentrate on the serious things rather than throw in.
Just give me the reference if you want.
Yes, it's I think it's at. Let me see. Yes, it's a paragraph 113 of my skeleton.
Okay, I'll find it there. Paragraph 113 of your skeleton. Okay, don't waste time.
It's 415 is the reference of that bundle, and it's paragraph 127.
Okay, thank you.
All right. Turning to the allegations themselves, the first answer to them is that before our ex-parte hearing, I sent to you both of Mr. Britton's affidavits in the Hong Kong proceedings. Your Excellency, you had read them and you confirmed to me at the very start of the hearing that you had read them and you had picked out some points that were of interest to you from reading them. Mr. Britton's case was in those affidavits. We even read those affidavits together as we went through the hearing. And the factual points which I'm accused of not telling you were in the affidavits too. Some of them we've actually highlighted and discussed. I'll go through that one by one, but those affidavits you had read carefully, and also we read again at the hearing. We took time to go through them. I remember bits of the hearing where we're reading them together. And I'll give you some examples of that. But looking at the specifics from Mr. Britton's evidence, which are the factual things, the first accusation he makes is about share certificates. And he says that I misled you because I didn't tell you that the fund mislead.
I'm afraid you've frozen, Mr. Holloway.
I think we may have lost Mr. Holloway.
Yes, I think we have. I'm sure it'll come back online.
Apologies, Your Excellency. We are trying to investigate what's happened with Mr. Holloway's room, and we'll update you as soon as we can.
Yes, of course.
With apologies, Your Excellency, I'm advised we're having some technical difficulties. Would it be possible to have a 5-minute recess?
Yes, of course. If you're having problems, yes, of course. Okay.
Thank you very much.
Yes, we'll come back at 10 to 11 Dubai time.
Thank you. Apologies again.
That's okay.
Just check you.
Just checking if anyone can hear us again.
Yeah, yes, Mr. David.
I can hear you. If you're ready to proceed.
I'm so sorry, it just crashed.
No, well, let's carry on rather than wait until
Yes.
10 to if you're up and running. Okay, Karen, you were talking about share certificates when you froze.
Yes. So the point is, we did discuss this, and we discussed what Mr. Britton had said about it. The hearing, because you had picked up on it when you've read his affidavits, and that's at page 1201. I think at the bottom of page 1201, we're actually discussing this point in the hearing. We both not long read the affidavit, but there was a discussion about whether shares had been share certificates. I'm sorry, scroll.
I can see what I said. I read his affidavit.
Yes. So we had said we hadn't been issued with share certificates. He says that you should have been told that he was saying that no share certificates been issued. But you were told that. You saw his affidavit and we discussed it. So that allegation is wrong. The next accusation that is made is Mr. Britton says that we're claiming more. The order is wider than it should be, and there's some sort of debate about the numbers. So he refers to that in his third affidavit at paragraph 156. But I'm not going to deal with that because my learned friend hasn't pursued it in his skeleton argument. So I'm assuming he's not pressing it.
Okay, you can come back to it and reply.
I'll come back to it if he replies, but he should also explain, if he's not pursuing it, why it was made in the first place.
Well, anyway, let's carry. I mean, these are all really reply points, so you can deal with them. If you've got something that's an eliminate point, like the fact that the share certificates were clearly discussed from the transcript, deal with that now. Otherwise, leave more nuanced arguments to reply.
Fair enough. The share register, again, it's not being pursued, but it shouldn't have been made because we did discuss that as well. From on the same page, you will see that we did discuss the share register, and you had expressed several times why hasn't it been produced, and it still hasn't. So that goes nowhere. And then we get to the next one that he makes, which is, we should have told you that he had no knowledge of our proprietary interest and was a purchaser for value without notice or some such thing. So it's not, first of all, it's not true that wasn't raised at the hearing. Not only had you read what he said about it in the affidavit, but I mentioned it specifically at the hearing, and you can see that at page, let me see, 1239.
Yeah, let's have a look.
Just at the top of that page, we're actually going through his affidavit at that point, paragraph by paragraph, and I'm telling you what he's been saying.
He did not know that we Techteryx had.
He says that he only dealt with FTT, he didn't know who we were, etc. And I put that to you. You read his affidavit. I referred to the paragraph numbers, and we're reading the affidavit together. It may not be, someone's looking at this, trying to pick out points to run. That may not be apparent, the ebb and flow of that hearing. But what we were doing was going through the affidavit together. You were reading exactly what he said, and his affidavit. I can take you to that. It's paragraphs 52 and 53.
No, as I say, these are more for your reply to Mr. Montague Smith's submissions, but if you've got some headline points, just deal with the headline points now.
Well, I think the question of knowledge, I mean, Mr. Montague Smith saying we haven't pleaded that. I've just shown you that where we've pleaded it. And he's saying, well, we should have told you what he was saying. We did tell you what he was saying, but it's just not true what he was saying. And you've seen that because he met Techteryx in November 2022. He had long calls with him in 2023.
Well, that's a different issue. That's actually on the merits. We're just dealing with the non-disclosure.
Yes, but I do want to make that point. Actually, just one point on this, if I may. Because,
well, yeah, I mean, I do understand the points that you make about Mr. Britton's knowledge. You've got the TrueCoin point in that you raised in your skeleton, in the various subscription agreements which were prior to December of 2020. You've got the custody points that are actually on the subscription and distribution. What are they called? Not notices. The distribution documents. So they refer to custody. You made that point yesterday. So you've got those documents that you say show that he had knowledge that FDT were not investing their own monies. Is that the point you wanted to make?
But I wanted to make one more point about it.
Okay.
Yesterday, I thought it best to do it here because it fits.
Okay.
I just want to turn you to what Mr. Britton said first. The affidavit that you read, it's at 1703.
Yep.
And just A1. He said in Hong Kong, Aria only had dealings with FDT. He said at all relevant times we dealt only with FDT. And then they say FDT positively represented as part of the subscription forms that it was investing in its own capacity in exchange for FDT funds. Now, I just want to look at this very quickly because that, in my submission, is a fiction, and you can see that.
Sorry, forgive me. I need to organise my notes. So we're going off on a tangent here. So this is Britain's not Mr. Britain's knowledge. And we start at 1703, which is what document is that? That's an affirmation.
First affidavit in Hong Kong.
That's first. Yes, where do you want to take me next?
Right, so that's what he said in Hong Kong, and he said that as a subscription process, FDT represented that they were acting in on their own account. But now I want to take you to the latest version of the story on those subscription forms. And if we can look at 4069, and this is his third affidavit. He has a little table now of the different subscription forms that are there. And if you look through the affidavit, what is clear is he's saying that the DMCC payment ones are the original ones. And then on the other side, you've got the fund ones, which are the backdated ones. So that's his current version of events. There are two sets of subscription forms. One of them was done at the time, the DMCC ones, and the others were done later, backdated, as we've seen. But I just want you to look at one of these original ones. Page 4077. 476.
4076. Okay.
Now, this is what Mr. Britton is saying is the original subscription forms, not the backdated ones that he did later.
Yeah, this is a class B share. So the class Bs are Dmcc, and the class C shares are the fund. Yeah. Okay.
If you go down a page, first of all, you notice something that Your Excellency picked up right at the beginning before anybody else did. But you've got clause 17 there on the right-hand side.
Sorry, I need to blow this up.
Yes, it's good to blow this one up, actually.
Okay. Where am I looking?
Clause 17 on the right-hand side.
Yeah. This subscription. Oh, yeah. So on the next page, so on the next page.
So you spotted this. It's a choice of UAE law and a non-exclusive UAE jurisdiction clause. So that's point number one. That's
sorry, can you so bear with me a second? Sorry, my computer's being a bit slow. Clause 17. Subscription. Yeah, okay.
Then on the left-hand side, and it is worth blowing this up as well, going down beyond the number box 6.
Sorry, where do I go?
Paragraph 6.
Yes.
Have 2 boxes.
If the subscriber is the beneficial owner.
Yes, you either tick one or the other. You're either a beneficial owner or you're subscribing on behalf of others.
Yeah.
And you will see that on all of the ones that he says are the originals, neither of these boxes has been ticked. I can give you all the references to them, but they're all the same. They have a UAE choice of law, a non-exclusive choice of UAE courts, and none of them has a box ticked saying one way or the other where somebody's investing on their own account or not. Now I want to take you to the backdated version of that one, which is page 4, page 4 of the exhibit 4080.
4080. Yep.
These backdated ones have a different choice of law clause in clause 17. It's now Cayman law.
And there's a tick in number 6.
Now, what we know, all of the backdated ones have added this tick box. So we don't know when these were created, and we don't know who did it, and we don't know who ticked that box. But what Mr. Britton is saying, right from the start, they represented that they were the beneficial owner themselves. But his allegedly original subscription forms don't have that. Only the backdated ones that were created later do have that. And so I say this whole thing is a fiction. Not only did I tell you that he was running that defence, but the defence is, in my submission, a fiction. He did know, and the backdated documents don't provide a basis for him to tell that he didn't know.
and FDT being beneficial owner would be contrary to the documents we discussed yesterday?
Well, it's not necessarily, but because of the subtrust. Sorry, yes, it would be indeed. But
yes, whether there's a trust or subtrust, it doesn't matter, because what FDT was telling Techteryx was that it only held, well, it only held a bare legal title, I think, is what I looked. Anyway, yes. I'll have to come to terms. I have to think about that.
Yes, indeed.
And Mr. Montague Smith can help me with that too.
But the idea that he thought that they were acting on their own only comes from these backdated documents, which he admits that he backdated, and that's very unreliable, to say the least. The next allegation is, I didn't tell you, or I said that the fund had defaulted on their redemption requests, which apparently is misleading. I'm supposed to have told you that there was a good defence or a good reason for that, to do with KYC. There has been a default in payment of redemptions, which and there's never been any suggestion at the time when the redemptions were due that was to do with KYC. Now, there is a throwaway paragraph in Mr. Britton's affidavit in Hong Kong, simply saying that that there were outstanding KYC issues. There's nothing in his affidavit that says that would provide a defence to this whole claim. The affidavit was before you, but in my submission, this is all, again, contested but concocted evidence. As far as Techteryx is concerned, they have confirmed who the ultimate beneficial owner is. My learned friend doesn't agree with that. That's something, to the extent that there is a dispute about it, is a triable issue, but it's not a major one. And I just don't see how it can be said that that's misleading. There were no redemptions at the time, and that's a fact. What my learned friend is relying on is an ex post facto email in 2024, simply asking who the ultimate beneficial owner of Techteryx is. They've been told that. They don't believe it. That's really, there's nothing really else I can, or anyone else can say about that. The next allegation is about the audited accounts. Your Excellency, I've touched on this before. Can I ask you to look at my learned friend's skeleton now at page 1384. Yes, paragraph. Oh, sorry, that must be a supplemental bundle. Yes, it is. Bear with me.
Is it supplemental?
So he says here that I positively misstated the position, stating that the fund has not produced any audited or unaudited financial statements for several consecutive years. But in fact, that's plainly right. There haven't been any. Certainly weren't any at the time. Now, what I think what my learned friend's getting at is that the first affidavit of Miss Lee said that we had received no audited financial statements. And in fact, we did have the statements for 2021, and that was a mistake. We've apologised for it. Before the first return date hearing, it was corrected, but the point still stands. We don't have the, regardless of what's about to be put before you, which was put together yesterday, we didn't have 2022, 23, 24, and there have been two versions of the 2021 accounts. That was a mistake. We've apologised. I don't see that it goes much further than that. The next thing is risk of dissipation. Mr. Britton says we say that there was a risk of dissipation and that was false. Well, that is a contested, obviously contested issue. I maintain there is a serious risk of dissipation here, and we did show it. I'll not deal with that too much. That's the kind of contested issue it's for your honour to decide whether you feel there's a risk of dissipation or not. We say there clearly is. He talks about investments in the fund. He says that we should have talked about the net asset value statements, but we did talk about that. And
sorry, where are we now?
I'm looking at the allegation in Mr. Britton's affidavit, paragraph 157. He says
Page
4065. So we said net asset value, we had looked at the net asset value statements and we were alarmed because what they showed was that large value of the assets was tied up in or came from intercompany receivables. And he says, well, that's misleading because
paragraph. Sorry, what paragraph? It's 157, is it?
157 is what is the allegation that he makes against me. And then 158, he says, I misled you because whilst I pointed to our concerns about the net asset value statement, I forgot to tell you that the PPM gave wide authority for them to invest the funds wherever they liked. I submit that's not the kind of allegation that can be construed as a full and frank complaint. That's plainly whether the investments were permitted under the PPM is plainly for trial. It's perfectly right for me to say we've looked at the net asset value statement and this is why we're worried about it. And in fact, as I've tried to explain to you yesterday, the concerns go much, much deeper than that on the net asset value statements. So I don't see how that can be a full and frank point. And then I'm going to get to the Hong Kong part. So contrary to what is now being said, Your Excellency, the common law test for enforcing foreign judgments was properly put to you at the ex parte hearing. First of all, it was in my skeleton at page 1067 of the supplementary bundle, paragraph 38.
1067.
Yes.
38.
Main bundle, sorry. It's the main bundle. Yes, it is. Sorry. Yes.
Yeah, I'm in the main bundle. I can see 1067.
Yes.
38. Okay.
So
yes, I have that.
Common law principles, and then you'll see footnote 9, and the footnote was the memorandum of guidance between the Hong Kong courts and the DIFC courts. That was properly put to you, and my learned friend said, for example, at the first return date, he said that I had buried that memorandum of guidance in the exhibits, and that's not right, because you, right at the start of the hearing, confirmed that you had received and read the memorandum of guidance, and So that was wrong at the return date hearing. But actually, today, my learned friend's going even further than that. And he says, paragraph 181 of his skeleton. I'll have to get the page reference for that. Sorry, bear with me. Bear with me.
That's all right. Just give me the paragraph number. I've got the skeleton separate.
Paragraph 81.
81. Yeah, I have that.
So today he's saying, sorry, it's the wrong paragraph, isn't it? Sorry.
I'm not sure it's 81.
80. One, I beg your pardon. Yes.
Oh, well, yeah, I thought so.
Yes, today he's saying that the common law test and the fact that allegedly proprietary orders can't be enforced are covered in the DIFC memo. This obviously relevant document should have been made available to the court also. That is an unfair submission, because what's being submitted there is that I didn't give you the memo, and you did have it, and you did refer to it, and I didn't bury it in the exhibits. No, so that's not properly put, that part of the skeleton. He then says that that I positively misrepresented to you that the enforcement of a Hong Kong judgment was not governed by common law rules, but was governed by the rules in Hong Kong, and that's wrong. I need to turn you to that passage in the transcript just to show you. It's at page 31 of the transcript, which is at 1226, I believe. So it's 31. No, there I begin by saying that we have to prove there's a good arguable case and a serious issue to be tried on the merits. We also need to show that a serious issue or a good arguable case that the judgment will be enforceable here. And you had already said that you had read the memo, and then I say, quite properly, that the first respondent was applying to the Hong Kong courts and making a challenge on forum non-convenience grounds to those proceedings.
Sorry, can you just help me? Where are you?
I'm on page 1226. You zoom on. And it is the paragraph beginning, Mr. Holloway, I guess the jurisdiction of this court.
Yes.
And then what I've done there is we've already established the common law and the memo are the guiding principles, and I'm telling you that the first respondent has made a challenge to the jurisdiction of the Hong Kong courts on forum non-convenience grounds. And the reason I'm telling you that is because obviously if the Hong Kong courts threw out the case, then I'd need to find another basis to persuade you to make the order. And then you say at the bottom of that page, and how can we have jurisdiction over Aria Dmcc in Hong Kong? They are a Hong Kong company, a Dubai company. I say yes. Sorry, scrolling down on the other page. And then I explain that what's happening in Hong Kong is that there's an anchor defendant, which is FTT, and the proceedings will proceed against Aria Dmcc because they're connected. in the way that we would consider necessary and proper parties. So what I'm talking about there is the jurisdiction challenge that's going on in Hong Kong and how that would impact these proceedings. And then you say, Your Excellency, do they have the same rules as us for necessary and proper parties? And I say, I think so. So that's what was going on there. I was telling you that they had made a challenge in Hong Kong, and that might impact on what we needed to do, because if they successfully challenged those proceedings, I would need to find another basis for the order. And if we go over the page, you can see that discussion progressing. Top of page 2028, and I say, okay, if they challenge jurisdiction and the Hong Kong courts throw this out, we're still going to have a claim against Aria Dmcc, and we're still going to want a freezing order. And you say, Your Excellency, okay, that's a dangerous submission, because I can give orders in support of the Hong Kong proceedings, but I wouldn't know where the other proceedings would be. So what we're discussing is the actual reality of what's going on in Hong Kong and how it would impact your jurisdiction to make a freezing order. I was answering your question about the jurisdiction challenge in Hong Kong. I was not telling you the rules to enforce a Hong Kong judgment in Dubai depend on Hong Kong law. Never said that.
As we go down the page, I mean, I may be told that my understanding was wrong. I said the only basis on which this court could make an order, if it was so minded, would be in order to prevent the proceeds of any judgment given in Hong Kong, which may be recognizable and enforceable in this court, being dissipated. Now, I may be told that I've misunderstood the jurisdiction of the court.
We both may have been being too conservative there, but the operative word is may.
Well, it may have changed. It may have changed with the court law. I mean, that's one of the interesting features that I'm going to have to grapple with.
The operative word is may, and the other operative word is recognizable or enforceable. So basically, what I mean, in my submission, what the authorities get to is, can you make an order that is going to help the Hong Kong courts? Can you make an order with teeth? I'll come to that. That's a separate submission. But what I was not doing there was misrepresenting to you the test for enforcement. That's wrong. We were having a discussion about the actual reality of what was happening in Hong Kong and how it would impact on any orders that you make. What we weren't doing is speculating about what would happen if they decided to boycott the proceedings, and would the judgment be enforceable in that scenario? That's utterly hypothetical, and we weren't talking about that. So that's what I say about that. Unless I can assist further, just.
No. We'll hear what Mr. Montague Smith has to say. It's a difficult area.
Now there are two more allegations crept in to Mr. Britton's his fourth affidavit. The first one is authorization. He said that we didn't draw the court's attention. So I am looking now at Mr. Britton's fourth affidavit, paragraph 58.
Page.
And that's 6644.
Thank you.
And he says that we should have taken you to the evidence that Mr. Delorraine was authorized by us to make these investments. Now, Your Honour, again, this is wrong. I mean, we had a lengthy discussion.
So I don't. you've already taken me to the fact that it's disputed that Mr. De Lorraine was acting with authority. You've shown me that there's a pleading that he was in breach of fiduciary duty.
Let me just say that we 7 pages of the transcript were devoted to discussing the authorisation of Mr. De Lorraine, and it's at page 1220, pages 23 to 30 of that transcript.
1223.
Yes.
1223 to 30. Let's have a look at that. Let me just have a quick look through.
Pages 7. Go to 1220. Sorry, it goes even before that. I think I've got that wrong.
Yeah, I can't see.
I think it's 1218 it starts, and it may be that my notes were.
Okay, let me go back. It's going back to 1218. Right. There we go. Now I go back. The other defence that they're running is that we authorise the payment.
Yes, and there's a lengthy discussion. I don't really need you to read it all, but we went through the whole documents. Can I just
let me just have a look at that.
Yeah.
Board memorandum. Yeah.
Yes, I think that's the.
Yeah. Okay.
1225, I think, is the one that I wanted to show you.
1225. Yeah.
The top there. Oh, sorry, bottom, is it? Oh, yeah, no, sorry. 1225.
Yes, it does not authorise a ratified duty of in the court of Mr. De Lorraine going off on a frolic of their own to make investments in Mr. Britain's wife's company. Okay.
Well, this is the paragraph that Alfred makes a lot of, but what we're saying here, he wasn't authorised to invest in DMCC, and that's the point. Regardless of whether they were conned into investing into the fund, he was not authorised to invest into DMCC, and there's nothing in the evidence or in Mr. De Lorraine's evidence or anywhere else that says that he was. So we've not misled anyone on that. And your conclusion at the end of that is, well, those are all eminently tribal issues, which they are. So,
okay.
Let me see if I've got anything. Oh, yes, the last one I'll take. There are 3 new allegations in my learned friend's skeleton argument at paragraph 184, page 1382.
Yeah, I have that.
Oh, that first one, well, actually, none of them are in the application, and none of them were flagged in evidence. So my first submission is they're several months too late to be made. There's no reason why those couldn't have been put properly in the application, but I'll deal with them anyway, because there's little point. I suggest there's nothing in this The first one, making no reference to authorities, explaining how a trust may be established. I don't see that is possibly a full and frank allegation. Our discussion in that ex-parte hearing focused squarely on whether there was an express trust or not. There are many, many alternative arguments, as we've seen in the past few days. Constructive trust and the whole thing is a fraud was an argument that was raised, but not pursued because, Your Excellency, you said at the beginning of the hearing, it's a short hearing. Let's focus on issue number 3. Was there a trust? And I did. But it's tribe law that a constructive trust can be imposed in cases of fraud. We've both cited the same authorities, and there is room for argument over whether they apply in Hong Kong, to what extent the fraud trust can be applied in Hong Kong. That's all triable stuff. But there's no... the basis on which you made the order was on the contract and on the documents, and that still stands. The additional arguments could have been elaborated. We could probably have a few weeks of argument on this, but that's for the trial, surely. Now, the second one is one that he ran at number B. He says that I wrongly described in 3 clear places that FDT are acting as fiduciary, holding the funds on our account, acting as trustee. Your Excellency, that I stand by that. Let's go back to the...
Well, no, I mean, I do recollect saying that it turns upon the question of the meaning of fiduciary and whether that implies they were acting as trustee or not. So we discussed the point, and I said that ultimately it's a matter of Hong Kong law.
Yes.
I mean, I have a very clear recollection of that.
Yes, but more than that, the only thing that is wrong there are 3 places in the agreement where it's acting as a trustee. I'll just give you the transcript reference, but I'll tell you what happened. That was my quote, acting as trustee. You then immediately said, where does it say acting as trustee? We went back to the recital and we read it again, and it said provides trust services, and you said, ah, yes, that's it. So if that wasn't a direct quote from the recital, we then went back and read it again, and you said, okay, now I see what you mean. So I can tell you what that is. It's 1211.
1211, let's have a look.
Yeah, so just above, so the bottom of 1211, come up a little bit. Is what I said.
So, yes, look.
And then you said, where does it say acting as trustee? And then we went back.
Government law, Hong Kong, yes, okay. Fiduciaries, difficult meanings, English law, I said, but Hong Kong law, maybe say English law. It does not mean they are not trustee.
So then I say,
yes, the argument about that. It was not highlighting that part of the clause.
the passage is, yes,
so I'm just reading it. Yeah.
Yes, yes. But then the next bit is where I say what I said.
Look at the side for the first. It's only other reference. Okay, so anyway, we had a discussion
then you say, where does it say acting as trustee? And I say, well, we looked at it, it's the recital, and then we went back to it. And then you say, was it recital A or 3A? And then it says, you look at it and you say, oh, I say the first recital. And then I correct myself, agree to provide trustee, custody and other, I read the thing out. And then you say, yes, that's where we started. So yes, it doesn't say agreed to act as trustee. It says agreed to provide trustee fiduciary. But this is very pedantic if that's the accusation, because if I did misstate the exact wording of that clause, we then went back and read it again, and that's what it says. And we looked at it again yesterday.
Okay.
And then the last one that Mr. Montague Smith says is, again, it's, sorry, paragraph 184 of his skeleton, the C. He says that I referred to clause 4F of the ESA, and all I said was that it just clarifies that if people have the right to redeem, that obviously no one can complain. If we get to the point, sorry, I've lost the reference on that.
I don't understand the point that's being made at C.
So the transcript, he says it's a 1211. Let's go to that. And honestly, let's go down to
11. Okay.
it might be further down. I believe that might be a wrong reference, but that may be because the bundle's changed. Yes, that's it. 1213. It's
1213.
Yeah, I'm going to the clause, and we went through it yesterday. Let's have a look at clause F. That's about 4F. That's about redemptions. And I say it's just clarifying people have the right to redeem the notes. Clause 4F, obviously, I may have misspoke. I may have been curtailed. It looks like the sentence has trailed off. But we were looking at clause 4F. So it's not that I was sort of withholding it. I just.
What is said to be the failure to disclose? What is said to have been undisclosed?
We talked about it yesterday. It was the exceptional clause about the triggering events and whether people could redeem directly to FTT.
Okay, but
yes, obviously didn't elaborate to that extent at the hearing, and it looks like my sentence was cut off. And we were talking.
It's just clarifying that if the people have the right to redeem, then obviously. I don't understand the point.
Well, it's a very great point, and I guess my own friends going to say 4F is very significant, and it has this resulting trust and so on and so forth. I get into it, and I was. So
the suggestion. Well, anyway, we better leave this for a response, I think. But so I mean, you believe the allegation is that you didn't flag up the triggering event. Resulting trust.
Yes, that whole argument about, I mean, it's obviously relevant perhaps to the construction of the whole agreements together. But look, at that hearing, there was no running away from the fact that the construction of those agreements is going to be disputed. It's going to be complicated.
Okay, well, let's move on and see how that's put. And then
I think that's the last one.
but I mean, there are four key omissions.
I think the others are wrapped up in ones that we've already done.
Yeah, but this paragraph speaks of four key omissions. So, property subject to trust, breach of trust, bona fide purchaser.
Oh, sorry, rescission. Yes, I haven't done that.
Rescission.
So he says that again, that what we're pleading in Hong Kong against his client is inconsistent with the pleading against TrueCoin in the other case, because the word rescission is mentioned in that pleading. Get my notes, sorry.
Yes, I see. I see the argument.
But yes, sorry. First of all, just the short answer is that that is a misunderstanding of what is pleaded against TrueCoin, and it's a pleading point at best. But if you look at what is pleaded against TrueCoin in the other case, I can take you to that, Your Honour. It's on page 815.
Okay, let's have a quick look.
In bundle. So yeah, this is the claim against D4. And this is the relief claimed against D4. And that is TrueCoin.
This is in relation to the pre-DMCC payments, isn't it? So this
Yes,
is
that's right.
97 million.
Yes.
Okay.
So to the extent that it is, well, I should point out that that claim has been stayed in the Hong Kong courts, not even going forward. But the relief being claimed against TrueCoin in those proceedings was not rescission and restitution ab initio. I mean, there's absolutely no way that my client would like to give TrueCoin back anything that they give following this fraud, and that's not what's being pleaded. That's not what's being claimed. The word rescission is used, but the language is that they're entitled to rescind the contract given what's happened, and damages in lieu of rescission are being claimed. That claim has been stayed, and this is, a very, very tangential pleading point. It was very briefly mentioned in Mr. Britton's Hong Kong affidavits, but I just submit that is not a material fact that you needed to be, that we needed to discuss in that 2-hour hearing. It's a.
Okay. Now I have the point.
No, I think I've come to the end, but I did want to talk about the actual law on enforcing Hong Kong judgments, but I realise I'm taking up too much of everybody's.
Well, I was going to take a break actually. So
you do it in 15 minutes and save the rest for a reply.
yes, okay. So let's take a break for 10 minutes, and then you can have 15 minutes, and that's it. Okay, so it's 11:38. Maybe we'll cut it down slightly. Let's come back 11:45, shall we? Have a shorter break. Okay.
Thanks.
Are we ready to resume?
Yes.
Mr. Montague-Smith, okay.
Yes, thank you. Sorry, I'm struggling to find a mute.
That's okay.
Okay, so I'll have to be very brief, sadly, on this, which is probably the most interesting part of it, but hopefully I'll get a chance to come back on it in reply. I think I'll start with what we agree on. I think we agree that the court has jurisdiction to make orders like these under both the old law and the new law. There's no point being taken on jurisdiction, and my learned friend has confirmed that a few times at the first confirmed date hearing. So then I'm going to look at the new law, just to give a flavour of this. What the new powers are is 9741 at the supplementary bundle.
Sorry, the supplementary bundle.
Yes, I think it must be, is it? Yes.
974.
It's the main bundle, I beg your pardon.
Sorry, main bundle.
Bundle, yes, sorry.
9741. Yes.
So we have 15.4 at page 9749, giving you jurisdiction to hear applications for interim and precautionary measures related to, and then applications, claims for current or future arbitral proceedings brought outside the DIFC seeking suitable precautionary measures within the DIFC. And on enforcement, it's according to Article 29, 4, that's it, page 9757, I think. And see. Sorry, I'm looking at some paragraph 4. I think it must be the wrong article. Scrolling down, enforcement rates. Sorry, it must be 31.4, I believe. Sorry, I've got this wrong. So the enforcement judge, when we're looking at enforcing an eventual judgment here, the enforcement judge shall have jurisdiction over the enforcement of judgments affixed, judgments and judicial decisions, I should say, affixed with the executory formula issued by local or foreign courts, including the divine courts, as well as interim precautionary measures and decisions made by local or foreign courts. So we've got in this new law a broad, open-ended jurisdiction on enforcement and on interim and precautionary measures. And of course, that's limited by your discretion and the precedents that have been developed over the court, by the court over the years. But I think just answering the big picture points that my learned friends made, because that's all I'm going to have time to do this morning. They are relying on strict rules about the enforcement of money judgments that will arise in Hong Kong, but they're ignoring the proprietary nature of this order, and the purpose of an order like that goes way beyond securing assets for enforcement. It also includes protecting the status quo, and being a proprietary order, it always includes an element of tracing. So what you're doing with the proprietary order is holding the ring while we work out where these assets are and who owns them. And I've cited in the skeleton passage from DEC on that. I'm not going to be able to give you too many references here, but it's in the skeleton. But that their argument focuses on a very narrow point of the freezing order. In fact, the point of your order is much wider. That's point one. Point two, we would say that this whole argument about whether the judgment would be enforceable or not is something that you can't really decide yet, because we don't know what's going to happen in Hong Kong as the proceedings unfold. We do know that they have participated, and we say that what they've done so far crosses the Rubicon, meaning that they've submitted themselves to the Hong Kong court to decide whether they should take the case, whether they should send it to Dubai, whether they should send it to Cayman. Now, I'm not. I've developed this in the skeleton, Your Excellency. I've cited the two common law cases, Dicey and Morris. I've cited Harris and Taylor, Henry and Giapresco. They're well-known common law cases. Both of those cases are very similar to what is going on in Hong Kong. You had defendants who applied to the courts to stay proceedings or for forum non-convenience grounds, and in the end didn't take any further part, and the judgments were enforceable against them. Now, you ran those arguments in Arabian construction, and Mr. Justice Giles said that he wasn't going to determine whether those common law cases were applicable in the DIFC because he had other reasons to distinguish that case from Harris and Taylor and Henry and Giapresco. We say it is at least arguable that they have submitted to the Hong Kong jurisdiction, because what they've done in those proceedings, you've read the affidavits, they've made detailed arguments about whether there's a proprietary interest, about whether there was authorization, about whether Mr. Britton was a bona fide purchaser for value without notice. Those are all in his affidavits in Hong Kong. And what he's asking the Hong Kong court to do effectively is to exercise its jurisdiction to decline the case on the basis that the merits.
That's their secondary. I mean, they do contest jurisdiction, and they say in the alternative, if there is jurisdiction, then forum non-convenience.
But they contest jurisdiction by saying that the order serving the proceedings out should be set aside because they're not present in the jurisdiction. There isn't an arguable case on the merits, and they run all those arguments, and then they say that the other courts are a more convenient forum. So what they're asking the court to do is make adjudication on the substance, and
But you have to make an adjudication on the substance on an application for service out, don't you?
Yes.
So they say, well, yes, we have argued the substance, but that's not a submission to the jurisdiction. That is purely in support of our contention that there's no case and therefore there should be no service out.
Well, that's what they say, but the common law authorities, before the law was changed in the UK, but two Court of Appeal authorities say that you can't do that. If you appear conditionally without being compelled to do so, the authorities say you have a choice. If you want to boycott the proceedings, you can boycott them. But if you take part and say to the court, exercise your jurisdiction, your discretion to either take or decline it, you're bound by that. And I know that's a strict rule, that's strict common law, and I know it's been modified by statute. But whether that strict common law rule applies here is up for debate, because paragraph 82 of Mr. Justice Giles' judgment in Arabian construction says...
Are we looking at it as a matter of DIFC law, as a matter of Hong Kong law?
Well,
we're talking about what they've done in Hong Kong in terms of submission to the jurisdiction of the Hong Kong court. So I can't immediately see why DIFC law is relevant to that issue. DIFC law is relevant to the issue of my jurisdiction and is relevant to the issue as to whether or not I even have to go down that route.
No, I mean, that would be accepting the premise that Mr. Montague-Smith accuses me of accepting, that it's all governed by Hong Kong law. This is DIFC conflict of laws. Did they submit to the jurisdiction under our law? And the question is, do you want to apply the strict test under the old common law, or do you want to move away from that? And I say it's not that you have to make a final decision on that, but you can say it at least is an arguable proposition that they have. That's one submission. The next one is that it doesn't matter, because this is the nature of this case that is one of substantial international fraud, and we've referred to two authorities there at DEC, page 1285. That's at paragraph 10051 of DEC.
Want me to turn that up?
Yes, please. And I'm
Okay.
reading 1284, and it's 10051. Now, what DEC is saying there is that under English law,
Sorry, 1280.
1285, I believe, 84. I'm sorry.
So, sorry, 1284. 1284.
284 of the supplementary bundle.
We're in the supplementary bundle.
Yeah, I'm sorry.
Okay. 1, 2. Supplementary. Yep.
So there's the first part of that, and they say beyond the two connecting links set out above, and that is the presence of the defendant in the jurisdiction and the presence of assets in the jurisdiction. There are exceptional cases in which there's a sufficient connection to justify the making of the order, etc. And the English courts have been astute to ensure that this possibility is left open, particularly in cases of international fraud. And then going to the next bit of the paragraph is that over the page, and there's a sentence beginning provided 4 or 5 lines, sorry, 6 or 7 lines down.
Yep.
Provided there's a right to issue proceedings in the foreign court, it may be appropriate for the English court to grant a freezing injunction in order to preserve the position for contribution between co-defendants against whom a claim of fraud is brought. The court cannot know what the ultimate result will be, whether as to contribution, availability of clean hands, etc. In the meantime, it may be appropriate to hold the ring. And I've got one more authority on that, which is the ArcelorMittal case, Mr. Justice Jacobs, who both my learned friend and I have referred to it. It's at page 166 of the supplemental bundle, paragraph 74.
Sorry, give me the page again.
Let me just, it's 74, so that is at 167.
167.
And we quoted this in the skeleton, and I wanted to read it. The second sentence, he regarded the present case as analogous to a case of international fraud, and in my judgment, he was right to do so. The evidence in that regard has in my view, strengthened since the without notice application, etc. They were not. And then moving on to 75, there's no precise definition of what is meant by the phrase international fraud in the case law. The underlying cause of action is deceit or a proprietary claim related to the theft of assets. If there's a strong case of serious wrongdoing on a larger repeated scale whereby a company or group of which it's a member is acting in a manner prejudicial to its creditors in bad faith, I see no reason why the English court should not be willing to intervene rather than to stand by and allow the conduct to continue and let the wrongdoer get away with it. And just the final points I'll make on this, Your Excellency, is that this is an important case because the jurisdiction you have to make orders like this was hard fought and developed by the judges of the court. In the cases of Latif, Jones and Jones, and we took a slightly backward step in the Sandra Holding case, but even in that case, the court recognised that where in exceptional circumstances, where the court had jurisdiction, it could act as what was called international policeman. And you're not the international policeman, you actually, but you are the Dubai policeman here. And given the new law, we would say it's very important that orders like this should be made and retained for two reasons. Number one, to continue this progressive development of the law, and number two,
leaving it. Sorry, I get all the policy stuff. The point that you make, which is interesting, I'm not saying other points aren't interesting, but the point that you make it was interesting in your skeleton is you say that under the new law there's no necessity to link the order to an ultimately enforceable judgment before this court.
If there ever was one, it was tethered jurisdictionally to the old, under the old law, because that was the basis on which the judges developed the law. It was the only jurisdictional peg that could.
Yeah, I understand all of that.
And now you've got specifically the jurisdiction to do so. Whether that peg is even needed anymore, I think what Your Honour should be considering is, yes, do I have jurisdiction to do this? Yes. Am I satisfied that the tests are met? Hopefully, yes, we would submit. Then is this order going to bite? Is it going to do any good? Is it going to help the Hong Kong courts? And we submit it already has done. You've got people in Dubai, you've got bank accounts in Dubai, you've got companies in Dubai. The Dubai courts couldn't give an order like this, but what they could do is enforce your order. And through that enforcement, we've got the only way we have of actually finding where these assets have gone. It's not going to be the Hong Kong courts who will help with that. It's going to be you and the Dubai courts working together. And I'm just going to, one final thought on this. I know the policy arguments are very well known to you, but we're embracing the digital economy here in Dubai, but we've got to make it a clean economy, and someone has to be making sure that this place is not seen as a safe haven for assets which are the proceeds of fraud. And what my learned friend is asking you to do is look away from the evidence, look at pleadings, look at professionals attacking them, attacking me, look at the evidence, and don't look away, Your Honour. And I believe this is an important case for many, many reasons, not just for our client. Thank you.
Okay, thank you very much, Mr. Holloway. Okay, Mr. Montague-Smith.
Thank you, Your Honour. With your permission, what I intended to do was this. I'm going to try to deal with the issues in the following order, if I may. First, I'll deal with the question of how Techteryx can have a claim at all. So that is the question of whether it is reasonably arguable that they have a proprietary interest in the reserves, which we say were invested in the fund. And so that's the question of the terms on which FDT held the funds. And that cuts across the whole of the way that the claim is put, because there is no claim unless you start from that premise, we say. And the points we say is quite a simple one, but I will spend, with your indulgence, a little bit of time on that because it is quite important. It's the central, a central plank of the claim. And the burden is on Techteryx to show how it has a claim. It needs to establish where it gets its proprietary interest from. And it, as we say, singularly failed to do that. Its approach is effectively to assert it and then to say, well, it's all very complicated, particularly the second half. There's two bits to the allegation. One is look at the terms of the ESA. Is that a fraud? Is that a trust? And I'll deal with that. But then my learned friend lobs in a whole series of other points. So he says, well, we don't actually need a trust if fiduciary duty is enough. He takes you to various cases and I'll have to go through them, but they don't get him anywhere. No subsequent breach of fiduciary duty can ever trigger a trust over property which is owned by FTT. That's the short proposition there. The second point then is whether my learned friend has a real prospect of success on breach of trust. So if the funds were held on trust by FTT for the benefit of Techteryx, what is the case of breach of trust as against FTT? What is the evidence in support of that case? And we say that the case advances self-contradictory in relation to that. And my learned friend flagged the point that we say that they positively assert that the payments were authorised. He didn't show you all of the relevant provisions in that particular pleading, and he very much mischaracterised my position on those pleadings. My position is not they haven't said fraud against against Aria, Dmcc, or against the fund. My point is that, well, I have a number of points in relation to that. But in particular, in relation to this part of it, we say that the claim for breach just doesn't stack up. And then going through what we see as the logical order, the next question is whether or not Aria has knowledge of that breach, because Aria would need to know two things. First, that the money was held on trust, not owned by FTT, and second, that the transfers were not authorised. Otherwise, they're bona fide purchaser for value. And we need to look there at the pleaded case. And this is one particular area where the pleadings in Hong Kong matter, to see whether or not that supports the case that's been made, and if that is, whether the evidence that you have before you supports those allegations. Fourth, I'm going to look at the various other ways in which the claim is put by Techteryx, so look at the pleaded claim in Hong Kong. There's been very little focus on that in my learned friend's submission. So there's a conspiracy claim and there's a misrep claim, and the true coin story is at the heart of most of that. And it's, as I understand it, it's not said that those give an independent basis for a claim if they can't succeed on their proprietary interest. And there's a reason for that, and we'll look at it. But ultimately, their claim is for the missing money.
Yes.
On any view, so it cuts across the quantum side of it.
Yes, I mean, one of the issues which you do ventilate in your skeleton is the difference between a proprietary injunction and a freezing injunction.
Yes,
and of course that might reflect different ways in which the case is put. So I guess you're going to address that.
Yes, quite well. The fundamentally the difference used to be in the threshold merits test in parts, and that's we accept has changed, and it's changed here. But ultimately, the way the case was put to you, your lordship, at the ex parte, and the way it's maintained here is that they accept they have to find a proprietary interest in the fund, because that leads to the loss that they would seek in relation to all the other elements.
So even if it's a damage, you say that even if it's a damages claim, there has to be a proprietary interest.
Right.
So, but if there's a pure misrep claim,
yes,
then there need not be a proprietary interest.
No, not to get to breach, but to get to loss. The way the loss is pleaded is simply we've lost the reserves.
Well, and yes, so but isn't it pleaded in a way that it was represented to them that this was a liquid investment, and this was and you know they quote various chunks of the PPM. And they say that they were misled into investing in the fund, let alone investing into DMCC. And wouldn't that lead to damages irrespective of a proprietary interest?
No, because they're not investing on this premise. So they're authorising FTD to invest FTT's own money. And
FTT,
if that money...
So they only act on instruction.
Yes, quite. But so one can see a breach claim against FDT. They're left with contractual remedies against FDT.
Yeah.
But then the claim needs to be, well, they would have to make some sort of claim that somehow they aren't still left with those claims against FDT. So in other words, they've got a contractual relationship with FDT. FDT needs to give them money back, but there's a contractual entitlements. So FDT goes off on a, as my learned friend put it, at the ex parte frolic of its own. What are they left with? Well, they're still left with their rights against FDT. Put them back in the position that they would otherwise have been. So there's no claim that's premised on, for example, FDT's insolvency or its inability to meet the debts, as we say they would be, or the contractual rights that are available to them. So there's no loss. And we can see that clearly from the pleadings, and we can also see it from the way this application has been put. So when my learned friend put the application to you, you'll see, we can go through it if you like, but in his skeleton argument for the ex parte, he said, here's the real prospect of success on the proprietary claim, you know, and goes through it. And then when he gets to good arguable case, he says, well, I just refer back to everything I said before. So he doesn't say, well, there's a separate allegation being made. So if one thinks it through, what's the loss in that scenario? The loss in that scenario is nothing if they don't own that money, because if they don't own that money, FDT's just gone off and done something it shouldn't have done. The remedy is against FDT to replenish the account. So why is there then a claim against Aria? There isn't one. There isn't a claim against Aria in relation to that. So there is not that as a matter of logic, and a matter of the way the case is put in Hong Kong, as the matter of the way the case is put before you, they require a proprietary claim, and that's never been challenged. In this context, I was going to look then at the argument that the fund is a fraud, and ask, firstly, even if that's established, where does that actually take Techteryx on this claim? And second, what is the case actually put, and what of that is made out before the court? And again, our threshold submission is that your lordship has to focus on the pleaded allegations. It is not enough to plead there has been a fraud. That on the authorities 100%, that is insufficient. If you want to establish a fraud by inference, you need to identify and plead out the underlying primary facts on the basis of which that fraud is established. And what you cannot have, and what you're faced with today, is an exercise in a party just saying, well, here are a bunch of red flags, and coming up with new ones during the course of the hearing. So my primary concern about the bank statements that were introduced, for example, was not the mere fact of those bank statements being introduced. It's my learned friends saying, oh, well, you can see payments here which are unexplained, and one can infer from that this is all a fraud. He never actually builds that case for you. He never actually analyzes back from his underlying point why that it's legitimate, and indeed, as we would say, it has to be necessary to infer from those facts the kind of fraud which he is asserting, which in itself remains difficult. And so what you're having, what these proceedings have been an exercise in, is a moving target of a flurry of allegations, of new points being raised, and all of that was happening in the course of yesterday. Not much that you heard yesterday from my learned friend reflects anything that was said in a particularized way, at least in his skeleton argument. And there were lots of new allegations that were being raised all along. So we are going to ask you to focus on those. We will deal with those allegations as best we can, and to some extent we're trying to do that. We will try and give you answers to those points. But it's very easy to show up and say, well, there's a lot of unexplained stuff about these accounts, but this process is not an audit of the last 4 years of the fund. And that's effectively what my learned friend is trying to turn it into. And he's raising audit style points and saying, oh, well, there's no evidence.
I should be focusing, if I focus on anything, on the 6 payments.
Yes, you should be focusing on the 6 payments, and you should be focusing on what are the allegations. So I'll give you what we say has happened to those, and I'll explain to you why we say you can have some prima facie happy, you can be comfortable that what is with the position that you're left with. I mean, apart from anything else, we've got the final version of the accounts, which Mazars we hope will sign off on today and tomorrow. There has been an audit. It is for the relevant period. My own friend said it wasn't captured in the 2020, 2021 audited accounts. It is in part, and the rest of it is captured in the 2022 accounts. And so where we get to is we say, well, look, ultimately what you've got is you've got a fund that exists, you've got shares in that fund, you've got assets in the fund which are of value. My own friend takes a number of pot shots at the values, and we'll try and meet those as best we can. We tried to meet the points he made previously, and he's met a bunch of new ones yesterday. Try and deal with those. But fundamentally, there have been redemptions. And then there's this complaint about securitization, which I'm afraid, have never understood. I understand that leads to increased liquidity, but that's the whole point of doing the securitization. So except that in a vacuum, that can increase the risk of dissipation. But we've always been upfront about the fact that process was going to be undertaken, to the point that in these proceedings, when we said we don't think your lordship's order captured securitization, we didn't just go ahead and do it. We wrote to the other side. In fact, they took advice, wrote to the other side and said that we don't see a problem here, but we give you notice of what we're going to do, so that nobody can say that we're trying to do this behind your back. So I will deal with those sorts of points, and then I will try and pick up the points that are made. But ultimately,
just on accounts, I did notice that we've got DMCC's accounts for the 2 relevant years in the bundle. I wouldn't mind a bit of help with those.
Right, I will try and do that. I may have to do that tomorrow.
Yes, of course. No. I just wanted to see, because obviously they should be back to back with the funds account.
Well, I don't think you'll be able to sort of match them together like a jigsaw puzzle. They should be consistent with one another.
Well, they should show the loan. They should show the loan. One should be able to trace the loan through. Which I mean, I'm not very good at reading accounts.
I see.
So I need some help.
Right. Well, I'll try and assist you with that as best I can. So we'll try and match up those loans. But leave that with me. But I think I'll go through that. I don't think I'll get onto that probably until deep into this afternoon, or possibly even tomorrow morning. But let's see.
I mean, just in terms of timing, I'll stop interrupting you, because I said I wasn't going to interrupt. Just in terms of timing, we are very pressed for time, I think, now.
So I've got some timings. My learned friend has taken, if you allow for the housekeeping and breaks, in total 6.75 hours. So he has 3/4 of an hour left for his reply tomorrow. I propose to take the hour until lunch, of which I've had 20 minutes, although he took 10 of those. 2.25 hours this afternoon, which excludes the breaks. And then that leaves me 2.75 hours tomorrow morning, excluding breaks. So that takes me 6 hours up to lunchtime tomorrow, which leaves me an hour and a half of time. And I propose to split that 1 hour after lunch and 30 minutes in reply to his 45 minutes of reply. Okay,
because what I was going to say is I'm pretty flexible in terms of timing. And I'm also available on Thursday if that becomes necessary.
That's very helpful, thank you. I think that would work potentially, but let's see how we go.
Yes, well, you can speak to each other, and if you feel that you're both up against time and there's more that you want to tell me, then I'm happy to make the time available.
That's very kind, thank you. I have another engagement that comes up after, which might make that difficult. We'll consider that. But let's. I was taking you through my agenda.
Yes.
So the funders of fraud comes in at that stage, but it is necessary just to think about how that affects things. And what is the evidence actually in support, and what is the inferential case being made out here, by reference to what's actually pleaded first, but also by reference to what we've had notice of. The fifth question then is the one that my learned friend was just dealing with, which is the question of whether, even if the claim succeeds in Hong Kong, the judgment would be enforceable in this court. And that question of submission is one of DIFC law, in the sense that DIFC needs to be satisfied on its own rules that there has been submission in Hong Kong. And we do say in that context, Your Lordship was quite obviously given the wrong test at the stage of the ex parte hearing, and was positively misled by that. And we don't shy away from that. My learned friend tries to
I may have misled myself. I may have misunderstood the test myself.
It's not your, yeah, perhaps, but it's not. That's not your responsibility, my lord. It's for my learned friend to explain that to Your Lordship. And what happened there was, what's happening now is you've got, for the first time in the skeleton arguments, an attempt to backfill that with an allegation that there's been submission in Hong Kong. That's the first time that's been said in the skeleton argument. That turns on facts, which is precisely the reason why the ACC appeal failed, and is another example of this sort of moving feast that we're supposed to be trying to answer. But in any event, it relies on a false characterization of the application in Hong Kong. What my learned friend says in his skeleton argument about what's happening in Hong Kong is factually false, and those sorts of allegations, those sorts of errors should not happen. He says there's no contest to the actual jurisdiction of the Hong Kong court. That is not true.
I think there is, from what I've read.
What he's telling you is not true. It's very unfortunate. And then finally, I will I think probably rapidly by this stage, look at the balance of convenience and just inconvenience case, before handing over to my junior, Mr. McPherson, who, with your permission, will be dealing with the full and frank points. And in relation to those, just as a headline, my learned friend says, well, if there's a factual dispute, we don't need to tell you. That is a mischaracterization of the test. The test is, if the existence of the full and frank point turns on a dispute of facts, then it may not need to be raised. But the mere fact that there is a defense out there which turns on disputed facts does not relieve a party of raising it. You have to put forward the defences and the possible defences of the other parties, whether they turn on law, whether they turn on facts. But there may be circumstances where, for example, there is a factual dispute. So it may be said, for example, all right, we told you all of this in a meeting. Answer, well, we disagree that meeting occurred. And so in those circumstances, the court would have to resolve the facts to decide whether there was a material point at all out there. It is not, as my learned friend has submitted, and that may explain why we say he has. His presentation on this, we don't shy away from saying that it was extremely one-sided and you were not given the assistance that you should have had. So I'm going to start then with Techteryx's entitlement in the first place. And my learned friend's approach to this was really, having given the sort of spray of complaints about the fund is the fraud and we don't have enough information about X, Y, and Z, he then said, well, that all explains why there's a good arguable case that these funds have been misappropriated. But the first stage of the analysis, as I say, has to be on whether or not the claimant can establish a proprietary interest in the reserves in the first place. And that is the basis, as I say, on which the claim was advanced in the ex parte hearing. Just to make that good, you'll see page 56 of the bundle. This is the main bundle. This is Ms. Lee's affirmation. Paragraph 62, and I'm not going to ask you to read it out, but there she sets out the Hong Kong claims, or what the claims are necessarily does so by reference to what is in the Hong Kong pleadings. And if you go to page 59, she then relies on paragraph 64. She sets, this is what we rely on, and refers back to the Hong Kong claims. And so there has, we say, been a significant degree of creep in the claimant's case, because essentially new claims are being suggested, which might be, for example, for, in the event that the ESA is void or something, or possibly if it's been rescinded, but it's all very vague. Because my learned friend's subsidiary case, its secondary cases, or fraud is enough, and he takes you to cases like AGIP. And actually, when you analyse that, that all turns on him having to say that some relevant contract under which money was paid is rescindable or void, and has been rescinded. Void or rescindable and has been rescinded. But none of that emerges from the Hong Kong pleading. So actually implicit in some of his ways that he puts this part of it is an entirely unpleaded case. And then there is also, you may not have caught this, but an unpleaded application as well, because he says, oh, well, if I can't get home on a freezing order against you, I could have a non-cause of action defendant freezer against FDT. That's buried in his skeleton argument. But again, there's no application for that. Right? We say that you should just put those sorts of things to one side. The main concern should be in considering the Hong Kong pleaded case, seeing whether it gives rise to the claims that are asserted, and if so, whether that's supported by the evidence. And we see that in the Tugashev case. So I can show you one, you were taken to some of this, but just to show you one short passage, supplementary bundle 3105, if my adding of page at 661 pages is accurate. It's paragraph 7.4 of that. This is Tugashev, and this is Mrs. Justice Carr as she was. And it's subparagraph 7.4, and it's the last sentence on that page, where she says the urgency of a particular case may make it necessary for evidence to be in a less tidy or complete form than is desirable. But no amount of urgency or practical difficulty can justify a failure to identify the relevant cause of action and the principal facts to be relied on. That was said in the context of the duty of full and frank disclosure, but it's of general application. It's not, we say, open to a party to backfill in the way that my learned friend is doing. And that applies all the more so where the application is made in support of foreign proceedings, and all the more so where the application is made in support of a claim in fraud. So the first question then is, were the reserves held on trust for Techteryx by FDT, or indeed on a sub-trust for token holders, or were they held absolutely by FDT and legacy but subject to contractual rights? And if the former, so if there's a trust or sub-trust, then in principle the beneficiary can follow the money if it's paid out in breach of trust to someone who's not a bona fide purchaser for value. But of course, if it's the latter, then the claimant's just left with contractual claims against FDT and legacy, potentially. So just to start with the skeleton argument, I don't know if you've got my learned friend's skeleton.
Yes, I do. Sorry, just before you leave that point.
Yes.
If FDT was holding pursuant to a contract, but the money was misapplied in some way, is it possible there may be a constructive trust?
Right, I'll come on to this as a secondary part of it. So there's, I'm going to deal with it in two parts. The first is, did they hold?
I was trying to phrase that very carefully, so I didn't.
Yes. No, I fully understand the point.
Yes.
The answer is the profit that is generated from the misapplication. There is an argument that it might, but we would say you can't. Okay. There always needs to be, my primary position is there needs to be a proprietary claim or interest in this fund first, before you can get a constructive trust on the misapplication of that money.
Okay, well, I do need to be addressed on constructive
I
trust.
will.
Yeah,
I will.
okay.
So, but I want to start with the express trust case first, because that's what's said. So it's being said that you've got an express trust when you look at the terms of these agreements.
Okay. What paragraph do you want to go to?
It was 71.1.
So I have both skeleton separately. So that's
very helpful.
I have it.
So paragraph 71 starts on page 30 and explains why there's a serious issue to be tried, and then goes on 71.1. The primary case is that the claimant owned the cash, and then 71.2 and 71.3 are intended to support that. So that's the case that it's the claimant's money, absolutely, when received from token holders, and it's handed to FDT on trust, and they rely on the true USD terms of service, which we'll have a look at briefly to support that. Then, rather oddly, they present the alternative case first, which is 71.4. They say, alternatively, the claimant's case is that it holds the beneficial interest in the reserves for the benefit of token holders by way of subtrust. So that's the secondary case. And then thirdly, 71.5, they say FDT held the reserves on trust for the claimant. And there's various positions that have to be unpacked, and my own friend expanded on them at length yesterday. Not really particularized here, but they say firstly, there's an express trust. Secondly, they don't need a trust. It's enough to have a fiduciary relationship. And then they say, well, it's enough actually to have fraud, even if there's no fiduciary relationship. So that really encapsulates the entire case in those two paragraphs. So, and we say the critical issue in all of this is what are the terms on which holders, firstly, on which token holders handed money to claimant, and then secondly, what are the terms on which the claimant handed the money to FDT? Of course, that's something of a fiction, because token holders give the money direct to FDT, but your lordship will remember that provision in clause 4A, we'll come back to it, which says that FDT was appointed as agent for receipt. So FDT can give good receipt for the money to token holders. But if one takes it in those two stages, it seems to us to make everything quite a lot clearer. So A, money goes from holders to claimant on what terms? B, money goes from claimant to FDT on what terms? And then C, we'll come on to all these other constructive trust arguments. What about what happens next if there is some sort of supervening fraud after that? And the first two questions are answered solely by the terms of the agreements. So first between holders and Techteryx, and secondly between Techteryx and FDT. We have recently been provided with those terms, and we say they rather, on the first stage of the argument, they rather demolish the argument that there could be a subtrust. Because to have a subtrust, you would have to have a trust at that first stage. You would have to have holders handing to claimant on trust. And if, as the claimant says, the holders gave up their interest in the cash at that point, well, that's the end of that argument. But I'll come on to the terms in a moment, just to deal with the principles first, if I may, because as we said, to get to the answer of whether the reserves are held on trust, you need to look at the terms of the relevant agreements. And we say that that's the first principle. It's all about the terms. And the second principle is that the law is slow to imply a trust in a commercial context. We start with a case called the Stadium Project, and I'll just show you a short passage in the supplementary bundle, if I may, and that is at page 2373. Oh, and yes, of course, my learned friend yesterday said, well, then maybe there's a quizclose trust as well. He picked that up and rather opportunistically ran with it. But you will see there's also reference in this case, this is the Stadium Project case, paragraph 36 to the quizclose trust. But the quizclose trust argument is ruled out because there was nothing in the agreement to that effect.
So it's what effect?
To the effect that they would be held on quizclose trust. But I'll come back to quizclose trust in a moment, because that's a new argument that's run by my learned friend. But paragraph 37 of this judgment, just the first sentence really encapsulates the point. The question of whether NH had a beneficial interest in the fund depends on the mutual intention of the relevant parties in establishing the suite of agreements for the implementation of the project. And then over paragraph 38, an objective approach to identification of intention where a trust is claimed is always appropriate, since the trustee and any beneficiary need to know what their obligations and rights are and need to ascertain this from the objective circumstances giving rise to the trust. It is especially important in a commercial context like the present, where the trust which is claimed to exist is enmeshed in and is said to arise out of a network of agreements put in place to accommodate the interests of a range of participants in the project. We can skip the next sentence, but just to go on to the final bit, to state the obvious, if certain contractors, in this case NH or ICS, are able to assert a beneficial interest in a trust in respect of a substantial part of the funds made available for a development scheme, they will obtain preferential treatment as against other contractors if the scheme runs into difficulties and the funding entity becomes insolvent. In a context like this, a court will be astute to ensure that a trust relationship in respect of money held to fund the scheme is clearly indicated in the contractual documentation. A trust will not readily be found to exist if that would undermine or contradict what appears to be a network of purely contractual relationships, providing on their face for personal rather than proprietary rights as between the participants. And that last point is a general one, and we pick up another short passage, if I may, in Snell at 3394. This is supplementary bundle 3394. And I'm showing you a passage at paragraph 22015 of Snell. And again, I can show you a very short passage, which is the second paragraph down. It was if you're looking for it, 3394. It has been said that there is a general disinclination of the courts to see the intricacies and doctrines connected with trusts introduced into everyday commercial transactions. The imposition of a trust without strong evidence of an intention to declare one would upset the usual proportionate distribution of assets in insolvency. Right, so that's the backdrop against which we construe these terms, and really what I'm going to do is set out, is just cut to the chase, and then try and pick up some of these other arguments made against me. So if we go to page 533, please, which you have seen.
533 of the main bundle.
Sorry, the main bundle, correct? Yes, please. And this is the ESA. You've seen this, but I'd like to show you it again so I can tell you what I say about it. 533. And so what it says, clause 6, this is the escrow amount. So this is defining the terms on which the escrow amount is held. FDT shall hold and manage the escrow amount as a fiduciary for the benefit of the client or its agents or designees. So well, I'll deal with the as a fiduciary point in a moment, but this is overriding language that comes next. for the avoidance of doubt. So that is overriding everything else that comes before. The client shall have no proprietary rights in the escrow amount and shall hold the escrow amount exclusively for the benefit of the holders. Now I'll come on to how we might interpret that latter part of it, but the first part of it, I'll deal with that. But the first part of it is the beginning of the sentence: for the avoidance of doubt, the client shall have no proprietary rights. And of course, the claim is that the claimant has proprietary rights. That's the nature of the claim that's being advanced to you today. And this clause is the clause that governs the relationship. And so we say that it makes the claim not just difficult, but impossible, because it is the claim is flatly inconsistent with the terms on which the parties agreed the money would be held. So just to break it down into the two different ways that the claim is put, these two alternative cases. The primary case is that the holders hand the cash to the claimant absolutely. So the claimant has this cash from token holders completely. That now belongs to Techteryx, and the cash is then handed to the claimant by the claimant, to FDT on these terms. Is this capable of giving rise to a trust over those monies? We say no, because it makes abundantly clear the claimant has no proprietary rights in the escrow amount. So if we're just talking about a bare trust, or not a bare trust, but a primary trust between FDT as trustee and the claimant, what could those words mean if that was the true position? It's very difficult to explain those words, and my learned friend provides no explanation for those words, which could be consistent. So then the question is, well, is this somehow displaced by the second half of it, which says, and shall hold the escrow amount exclusively for the benefit of the holders? Well, on any view that, sorry, I'll give you a moment to.
That's all right.
Not at all.
Okay.
On any view suggesting that the client holds the escrow amount, on any view that is curious language. Why do I say that? Because look at the previous sentence of the contract. Previous sentence of the contract says FDT shall hold and manage the escrow amount. So we know that the agreement is that FDT holds the amount in the language of the contract. So there's something that's gone slightly askew with suggesting that the client shall hold the escrow amount exclusively for the benefit of holders. So what can that mean? The client shall hold the escrow amount. It can't really mean they shall hold it as trustee. What it must be referring to, what it holds, is its rights in relation to that amount. And so to suggest that that language, the client shall hold the escrow amount, implies some sort of trust relationship, is we say, begging the question. Because if actually, by saying for the avoidance of doubt, the client shall have no proprietary rights, as it on its face is confining the client, Techteryx, to contractual rights, then the only thing that the client can hold are those contractual rights.
So it should read, shall hold the contractual rights, the escrow amount, exclusively for the benefit of the holder.
I'm not suggesting it needs to be rectified, but that would be a reading of it. I don't say that it should read that.
But if you're rectifying, and if you're inserting words as a reading, why not insert the words and FDT shall hold the escrow? No.
Well, why? So that the FDT is so that would be for FDT and the claimant to come together to declare Well, it depends what you mean by hold for their benefit.
Well,
To
yes, but
To
I mean,
declare a trust in favour of holders, then.
well, that's one possibility, isn't it? Because the only person who holds the escrow amount is FDT.
Yes. So then the question is, and I'll come on to, so it's never been suggested that FDT is holding the funds, the reserves on trust for holders.
Well, that's a subtrust. That's a subtrust argument.
No, that wouldn't be a subtrust argument. That would be a direct trust with no involvement of Techteryx. Because if FDT is holding the accounts exclusively for the benefit of holders, there's no room for Techteryx in that analysis. It's only the only place that you could get to some sort of trust involving Techteryx is if you interpret those words "and shall hold" as referring to Techteryx holding something. There's nowhere else where there could be anywhere else in this agreement which should suggest that Techteryx is involved after that. That's the primary place. This is the agreement as to how it is held.
Yes, I mean, we can look at the other. We can look at the other agreements too. Yeah.
Well, we'll look at the other agreements too, and we'll look at the other clauses. But
yes,
if one is thinking down this subtrust argument, where does it come from? Because firstly, even a subtrust would require the claimant to have a proprietary interest. So that is because of the way that subtrusts work, and I can show you this from the Lehman Rascals case, which is explained in a single paragraph. And this is, by the way, not the way that any of this is put. This is one where I haven't done the updating. Bear with me, I'm so sorry.
okay.
I need to add 661 to 1443. I cannot do it in my head, I'm afraid. So it should have it at 2104. Yes, of the supplementary bundle. So you can stay on that page.
Yeah.
And it's paragraph 226. This is the 2104, paragraph 226, and it's starting from the second sentence. It is common ground that a trust may exist, not merely between a legal owner and ultimate beneficial owner, but at each stage of a chain between them. So that, for example, A may hold on trust for X, X on trust for Y, and Y on trust for B. The only true trust of the property itself is that of A for X. At each lower stage of the chain, the intermediate trustee holds on trust only his interest in the property held on trust for him. That is how the holding of intermediate securities works under English law, wherever a proprietary interest is to be conferred on the ultimate investor. So at the top of the chain, if you have a subtrust which went from FDT, Techteryx, holders, what this analysis is saying is that the only true trust of the property itself is the one at the top, which is a trust that FDT is the trustee, Techteryx is the beneficiary. So that's a necessary and essential part of a subtrust analysis, is that the claimant has the beneficial interest. Now it holds that beneficial interest on trust itself for holders on this construct, but it still has a proprietary interest. But in any event, the point does not arise.
They say there's no trust relationship.
They say there's no trust. They say there's no trust. And you see that in their reply to FDT at page 4672 of the main bundle. Paragraph 16, middle of that, they say, specifically pursuant, do you have that? Specifically pursuant to the TrueCoin terms of use governing the purchase of purchasers, holders of tokens from TrueCoin. Tokens were purchased by purchasers, holders as items of property using fiat currency as consideration. The token holders thereby gave up their legal and beneficial interest in the sums transferred in return for receiving the tokens. And consistent with that, the escrow services agreement provided for FDT to hold the currency and any substitute assets for it on trust for the plaintiff. Now that's the bit that we're coming to, but that is the primary case over there. And that is supported now by the terms of use themselves. And in a sense, it doesn't much matter because my learned friend cannot come before you today and say, well, there's a good arguable case that my client holds on behalf of holders, because he doesn't advance that case. But just to give you some comfort, it's at the back of the main bundle in the supplements to that, which I think is in your bundle, my lord. And it's page 10487.
Yes. This is what?
These are the terms of use. This is the 2021 terms of use. You can see that from page 10486. And at 10487, under 4 services, does your lordship see there, amongst other things, at the end of the second paragraph, Techteryx itself does not guarantee any right of redemption or exchange of TUSD tokens for US dollars. And then secondly, we and our banking partners reserve the right to refuse to issue or redeem TUSD tokens for any reason, including without limitation, and then give some reasons. So they can say, you've got your token, you don't get your reserves. And the idea that they can refuse to hand over the money, the cash, is flatly inconsistent with the proposition that the holders own the money. And so flatly inconsistent with Techteryx being a sub-trustee. And the other point is we can see on page 10489, 2 pages onwards, under clause 11, this is page 10489, under heading risks. First, they say it's not a bank account. I suppose that's not inconsistent with there being some form of trust, but they're not saying you've got better than a bank account, you've got a trust. They're saying it's not a bank account. And then under FDIC coverage and sweeps, you will see in the second sentence of that, on the 3rd line, they talk about investments, and they say to achieve this, a portion of the dollar deposits backing TUSD are held in one or more depository accounts at our banking partners, whose deposits may not be insured by the Federal Deposit Insurance Corporation. And at the end of the next paragraph, therefore, in addition to the risks noted above, there may be a risk of loss to these funds associated with the solvency of the instruments being invested in other factors. So we can take from that that the funds from the token holders are not segregated, and they may be invested. And if one thinks it through, it's not that surprising that there aren't, however many TUSD tokens are out there, a trust in relation to each, or a trust in relation to each accumulated holder. But the fact that the funds are not segregated is a particular feature which counts against there being a trust. And I don't think I necessarily need to show you that, but I'll give you the reference if I may. It's on another unupdated reference. This was rather late last night, I'm afraid. The reference is page 2, supplemental bundle, page 2411, page 664.
So what's that a reference to?
let me just get it up and make sure I've got it.
241.
It's a case called the Techteryx and Nest Oy, and at the top left you'll see in the left-hand column reference to the fact that if the money is not segregated, then that is a strong indication that it's not held on trust. It's about 6 lines down. If, on the other hand, he's not bound to keep the money separate,
Yes,
entitled to mix it with his own money and deal with it as he pleases, and when called upon to hand over an equivalent sum of money, then, in my opinion, he's not a trustee. So my learned friend says, well, we've got an alternative case that there's a subtrust, but the subtrust case doesn't arise because the claimant's answer to the first question, did the token holders retain a beneficial interest, is no. They held no interest in the money. And it's not open to my learned friend to say, well, that's my position unless it causes me difficulty. That's not a genuine alternative case. You can't say, well, here's my position on the facts and the law unless it causes me difficulty, in which case I take a different position if it turns out that the consequences of my position are wrong. But you have to take it in stages, we say. What is the claimant's case on the terms on which they received the reserves? They put forward no positive case as to how they hold those on trust for holders. So there can be no good arguable case that the claimant is a sub-trustee of holders' interest. They need to show you the terms and explain how there's a real prospect of establishing that. But they don't do that. They do the opposite. But as I say, regardless of that, there's no way round clause 6 because both approaches, a primary trust or a subtrust, it's a necessary component. In fact, the only true trust over the property in both cases, even on the subtrust analysis, is a trust. FDT holds for Techteryx. That is a proprietary interest, either as the ultimate beneficiary or simply as holding it on trust for holders. Now, there are obviously a number of points that are taken against me in relation to that. And I was just going to run through, you wanted to see the other agreements, and I'll perhaps start there if I may. And the first is the client agreement at 492 of the main bundle. But that agreement, well, I don't really need to show it to you because I'm not sure much is said about it. It's the client agreement itself. It's the umbrella agreement under which various different facilities and services were going to be advanced, and there's no particular provision of that which assists. I think my learned friends. I would just show you one point though, which is at page 493. Beg pardon. Sorry. A lot of messages.
Well, we're coming up to 1 o'clock. Would it help if we rose now and you take those messages on board?
I think no, sorry, they're not necessarily from my people who are involved in this. I'm sorry. So I think that the overarching point that I was going to make in relation to these is, first, this is an umbrella agreement. It is not directed at the particular escrow account that is involved here, and the terms of the ESA override any other agreement. So that's the first point. And then the second point is, if one goes to page 493 and looks at the definition of service, there is a consistent, and this is consistent throughout all of the agreements, we would say, there is a distinction. It's in the middle of the page. Service means one or more and then it provides a different kind of capacity that FDT might provide or engage in. And it says one or more trustee, fiduciary, custody services, or other ad hoc services. So we say that these agreements consistently distinguish between, on the one hand, trustee services and custody services, and on the other hand, fiduciary services. So this is a sophisticated agreement where the drafters know the difference between trustees, trusts on the one hand, and fiduciaries and fiduciary duties on the other. I don't know whether there's time. It is 10 o'clock. I was going to come on to the custody services, the CSA, the custody services agreement, briefly next.
I think there's a bit to say about that. Well, shall we deal with that after lunch?
About the custody service agreement, yes. Yeah. I think that there's more to say. There's more to deal with on that. And
particularly section 6.
Yes. Yes. Well, I can give you the headline of what I'm going to say, which is that section 6 deals with capital P property. It doesn't deal with every service that's being provided or every thing that is transferred.
Capital P property includes cash.
Capital P property. Well, let's come back to it.
505. Property means, as the context requires, or any part of security, digital assets, cash, or any other property.
Yes, but held on behalf of the client.
Property.
So it says property means
being delivered to FDT or kept by FDT on the client's behalf, in each case until such assets are withdrawn pursuant to this agreement.
So I'm reading the definition of property on page 505.
Yes, am I.
It says all or any part of the any securities, digital asset, cash, or any other property that has been delivered to FDT to be
held by FDT.
No, sorry. That has been delivered to FDT to be held by FDT on client's behalf.
Yes.
So it's saying if property is delivered to FDT or to be held by FDT on client's behalf, then it counts as property. But not all cash is property. So if one goes up to the definition of property above at 504, cash is defined.
504.
Just the page before. It's the last.
Cash means okay. Sorry,
so it says
difficult to read.
I understand. Let me read it out very briefly.
No, it's okay. I just need to blow it. I can blow it up. Cash means all cash, any fiat currency received by the FDT from time to time for the account of the client, whether by way of deposit or arising out of or in connection with any property in the custody account. Okay, so I think that needs unpacking.
Well, I think just so you can think about this over the adjournment, perhaps, what that makes clear is that not all cash is property.
Okay.
All right, I'll leave that there for now, if I may.
Okay, so we'll take a break now for, well, it's a little past the hour, but we'll come back on the hour at 11 o'clock or 2 o'clock, as the case may be. Thank you very much.
We're all back. We are, I've just exchanged words with my old friend. I think we're both going to be in difficulty on Friday. Technically it's open in my diary, but I am under brief for the next thing. But I mean, I could in principle do it if we had to, but it sounds like my learned friend cannot. And I'm not sure my next clients would be terribly happy with me if I committed that day in any event. Also, we may just need to cut our cloth accordingly.
Well, as I say, I mean, I'm willing to sit a bit later tomorrow if entirely necessary.
We'll try and avoid that eventuality. With that in mind,
could I just chip in one small point on this, on the timings? I've accepted that I had 6 3/4 hours. My learning friend's going to have 2.5 hours after lunch, 3 hours tomorrow morning, and an hour before lunch. I think that takes him to just 15 minutes shy of what I had. So I think we should just split after lunch tomorrow with an hour each. I don't think there should be too much of. I certainly don't think there should be an extra hour after lunch tomorrow for main submission.
yeah, my learned friend's maths has gone wrong because he's forgetting about the breaks.
Look,
so-
I don't particularly want to get involved in arguments about how many minutes people have had. I leave it to your good sense to sort things out. And all I'm saying is, if you need me to sit past 4:30 tomorrow, I'm happy to do so.
Thank you very much.
Other than that, I don't really want to know.
I can understand that completely.
Okay.
Very well. With that in mind, and with your permission, I was going to take your Excellency back to the CSA, the Custody Services Agreement, and just make some short points in relation to that. So if we could go, please, to page 504 of the main bundle.
Yeah,
we were in it previously, and I just remind your Lordship that this is a document which is referring to, quote, custody services. So it is defining one type of service, which under the client agreement, the FDT was going to offer to provide to Techteryx. That's not to say that every service being provided was a custody service, and therefore it's the sort of primary starting point, we would say, is that this governs custody services, not the sort of escrow services that you see in the escrow services agreement. It's offering different services, and you can see that if we go forward to page 506. Well, sorry. Let's just do the property. So property, I'll just remind your Excellency, 505. Property means, as the context required, cash and so on, delivered to FDT to be held by FDT on client's behalf. So it's not saying everything that either Techteryx or indeed a holder sends to FDT is held on FDT's behalf in accordance with clause 6 of this agreement. It's saying in relation to property, which is property to be designated as being held on Techteryx's behalf, then that is held, that counts as property for the purposes of this agreement. So then we go forward to page 506 and clause 4.2, which deals with the custody accounts. And you'll see the setup of accounts. The client hereby instructs and authorizes FDT to establish on its books and records an account for the deposit of capital P property, brackets, custody account, that the FDT may receive from the client on the terms of this agreement. So what happens is that where FDT is going to provide custody services in relation to assets, then a custody account is established. And then if it goes over the page to 507, 6.2.1, we're dealing with the segregation of accounts. The FDT shall identify property on its records in a manner so that it is readily apparent the property, 1, belong to the client or its customers, 2, do not belong to the FDT or any other clients of the FDT, and 3, are segregated on the books and records of the FDT from the FDT's and its other clients' assets. Then, bear with me. Sorry, I missed out 6.1, designation of accounts. the FDT shall on its records identify each custody account in the name of the client or such other name as the client may reasonably designate. Custody account is to be designated to show that property belongs to the client and is segregated from the FDT's own account and those of the other clients of FDT. So this agreement is dealing very specifically with one particular type of service that is offered by FDT, custody services. Not all services are custody services. And it is saying what we do is we designate a custody account and then we hold in the custody account in your name certain monies, and then in relation to those monies, those are held in accordance with the terms of this agreement.
The
If we go the account,
the subscription agreements refer to custody account. This is that's FDT's reference to a custody account.
well, actually, if we got the document, because it's 5508 is FDT's account statement.
Yes, okay. Well, let's have a look at that.
Nobody has previously suggested that this is that it's held in a custody account. Nobody's previously suggested the escrow agreement is a custody account, and it's not. And there's a number of ways you can see that. One is from the escrow agreement itself, and I'll come on to that.
I've not seen this before. Yeah.
Well, my learned friend referred to it, but didn't take you to it, and said there's an account statement and it's segregated. And you said, well, it's referred to in the skeleton argument, so he didn't go there. But this is the document, and it's the account portfolio summary of the escrow account. And you'll see under account type, it doesn't say escrow account. Sorry, that doesn't say custody account. It says bespoke. TUSD. Three lines down from the top.
Okay. And this is a very new document. This is 2nd May.
This is an FDT printout of the escrow account.
Custody number.
But account type, bespoke. Yeah. TUSD escrow. So nobody is suggesting that this is the account. Sorry, that this account, which is the escrow account, is a custody account within the meaning of the services provided. So that's the starting point, that on the terms of the CSA, that is the custody services agreement, this account is simply outside the terms of the CSA to start with. And so you don't get anything from clause 6 of the CSA to start with, because it would have to first be property within the meaning of the contract. And that would have therefore to be money that was handed to FDT to be held by FDT on behalf of Techteryx.
Clause 6 doesn't apply.
I'm sorry?
You say clause 6 doesn't apply.
Of the custody services agreement.
Of the CSA, yeah.
Yes, correct.
Okay, so what do I take from 5508?
So from 5508, you get the statement of account. I mean, this is a factual issue about the terms on which the money in the escrow account was held by FDT, and what it supports, we say, is that this isn't a custody account. If that ever was alleged, it's not in fact being alleged, but it's because it supports that, because under the heading account type, it says bespoke. And so it's not consistent with the customer services agreement, because the the custody services agreement requires that it be designated as a custody account. That's simply support. What you're really interested in is the terms of the agreement itself. And what I'm saying is that the custody services agreement, you can't rely on that to determine whether or not the escrow monies were within or without of the custody services agreement. What that agreement is doing is it's saying, when you pass to us, FDT, money to be held on your behalf, this is how we will hold it on your behalf. That's the effect of the definition of property within the custody services agreement. That simply, it's not saying all money that you send us is going to be held in this way. It's saying when we hold money on your behalf, pursuant to custody, as when we provide you with custody services, these are the terms. So how do we know what are the terms on which the money is provided? And the answer to that is just in the ESA, in the escrow services agreement. That tells us all of the terms on which this particular amount of money is provided. And if we go to page 529 of the main bundle, remind your lordship of paragraph clause 1 of that agreement, which says, third line down, the terms and conditions set forth in this escrow services agreement are in addition to those set forth in the client agreement and the custody agreement, and that the former shall prevail for matters specifically dealt with in this escrow services agreement in case of conflict. And so I don't think there's any disagreement that that the terms of the ESA trump all other terms. So say I'm wrong about that and somehow clause 6 could apply to the terms on which this money was held. Well, the solution to that is that this is essentially in relation to these funds saying, well, they're different terms. They're the ones that we've got in this agreement. So if there's any inconsistency, we don't say that there is an inconsistency because of the way that the two agreements operate. But if there was inconsistency, then it's the ESA which prevails. And if we go down to page 535, you'll see clause 14. Entire agreement, which says, save and except for the client agreement, this escrow services agreement contains the entire agreement between the client and FDT regarding the escrow account. So it is not importing the custody services agreement into these terms at all. These are bespoke, as the account said. And so the result of it is that really we are looking at the clause, which is back on page 533, clause 6, and asking, what does it mean? Does it impose a trust over the escrow amount in favour of Techteryx, either as beneficial owner or as holding the beneficial ownership for the holders? And for the reasons I've explained, the law is slow to interpret and express trust into an agreement. B, it's clear. It says, for the avoidance of doubt, the client has no proprietary interest. And then it is right that there's reference to FDT holding as a fiduciary. And I'll just pick up that point now. And I hope it's not still being suggested that a fiduciary is always a trustee, or indeed that language indicates that there's a trustee involved. That is not the legal position. Agents and directors are fiduciaries, but it doesn't mean that they're trustees. And so it's the classic logical fallacy. All dogs have 4 legs, tables have 4 legs, all tables are dogs. It doesn't work like that. So I'll show you that very briefly. There's a passage in Lewin that we've referred to. It's Supplemental Authorities at page 1307. Supplementary 1307. And you were shown some of this, but not all of it. But because you were shown the bit that says, for the present purposes, trusts are not confined to trusts in the strict sense, but extend also to property, which at the outset is subject to a fiduciary relationship. It therefore suffices if the property is in the outright legal and beneficial ownership of some person, and another person, whom we call a quasi-trustee, has fiduciary duties in relation to the property. You have not read this bit, but it cannot be enough merely to establish that an agent has a personal duty to account to his principal and other personal fiduciary obligations, because there is no property in which the principal has any proprietary interest at all. So you cannot magic up a proprietary interest out of a fiduciary duty. And I'll come on to the constructive trust arguments in a moment, but just for the purposes of an express trust, the words fiduciary don't, we put the authorities in our skeleton, don't really tell you very much at all. The other bits of this agreement that were relied on by my learned friend were paragraph 3A, clause 3A, and the recital. Clause 3A, just dealing with that, I'm afraid backwards, but it makes sense to me. Clause 3A is at page 530. And it says, and it was the bit that says, during the escrow period, the parties agree, subject to the terms of the escrow services agreement, that 1, FDT will act as an agent of the client for the receipt of funds from the purchasers. Pausing there, that's just an agency relationship. And what that means is that when holders pay FDT directly, then the legal result is that the claimant can say, well, we've now received that money. So in other words, the agent, FDT, can give good receipt for cash from holders. And then secondly, it says, upon receipt, FDT will hold the funds as a fiduciary of the client to the order of the client, subject to section 4F. So I'll come on to section 4F in a moment, but again, that's just a fiduciary relationship. And C3, upon the extraction of the client, FDT shall redeem the tokens. So apart from anything else, you wouldn't need any of that if there was a trust. But certainly my learned friend can't rely on that as suggesting that there's a trust. The very language of it, the fact that it's incorporated, indicates there isn't a trust, because if it was just a trust, they'd have to do those things anyway. They just provide contractual duties that wouldn't be required if there was a trust in place. And if there was any doubt about that, then we say clause 6 would just sweep it away. And the other bit that my learned friend relied on was the recital at the top at page 529. And that the recital was presented as an indication that this document included trustee duties. Well, we'll come on to that later, I guess, but if that is the suggestion, it doesn't do anything of the sort, because all it does is describe the client agreement and the custody agreement. It doesn't add anything. And we say again, you see this, the very fact that the agreement distinguishes between different types of services, trustee, fiduciary, custody, indicates that the draftsman knew the difference. And where they wanted to say trustee, they said trustee. And we see that in clause 4F, which starts at page 531. So 4F deals with redemption, subject to clause 4C, purchase and redemption minimums. and the applicable terms of agreement as may be entered between the client and the holders. So that's
So your point is
subject.
that when they wanted to create a trust, they did expressly.
If you're well ahead of me, yes. Yeah, exactly. So if it, I mean, if one thought about it, it's quite a complicated analysis if there's already a trust in place, because you're going to have to collapse the existing trust in some way, discharge the existing trust, and then create a trust in favour of holders. And I suppose it's theoretically possible to create a new trust in favour of holders without holders being party to it. But if there's a sub-trust here,
It precludes the existence of a sub-trust because it would be unnecessary to have the resulting trust.
A, yes, but B also because there would need to be some agreement by the holders to their beneficial interests being rearranged in that way. They need to be party, and they're not. But sub-trust, we say, is a bit of a red herring anyway, because it requires that holders retain a beneficial interest, which we know that they do not.
Yes, but it can't be consistent, at least in terms of drafting, with the idea that the resulting trust only arises on a triggering event if there is a subsisting trust, which presumably would be in the same term.
We agree. So really what we say is that this is a very short point. It's just really clause 6. And it's embedded in this document, so you can get some input from it. But clause 6 says no proprietary interest in terms, in overriding language, and it's an overriding agreement. And that's the end of it, really. My learned friend referred, I don't know if I need to deal with this, but referred to the trust ordinance, which deals with how trust property is to be held. Does your lordship, I think your lordship has a point, but it's at supplementary bundle 3611, sorry, 3631. It's the my last page of it. And I'll just give you my submissions on that. He took you to section 89 of the trust ordinance. It's supplementary bundle 3631. And you can just see from the headings what's intended by this statute: trust funds to be kept separate. And they need to designate the trust to which such investments belong. That's the final bit of the language. So I think he's trying to say, well, this applies to all quotes fiduciaries, but one has to understand what the purpose of this is. It's not saying that anything FDT owns has to be held on trust. That would be absurd. FDT has to have its own money, has to pay its own staff, it has to pay for its leases and so on. I think, it is not suggesting that anything FDT holds and has agreed to hold as a fiduciary.
It's held by a trust company in a fiduciary capacity.
But you have to read that in its context, which is that it's talking about trust funds to be kept separate, section 89. And the requirement is that all investments made from it shall be so designated that the trusts to which such investments belong can be readily identified. That's the final sentence. And you can see it in the middle as well. They must be kept in separate accounts and so marked in the books of the company for each particular trust.
But certainly one reading, it equates in a fiduciary capacity with holding as a trustee on one reading.
Well, I mean, I don't think anyone is suggesting that as a matter of Hong Kong law, you can't have a fiduciary who is not a trustee.
No, but this is a trust company holding something in a fiduciary capacity. That's what this is about. So it's quite specific in that respect.
Yes, but it's definitely dealing with it. It's not suggesting that there's some sort of overlay of trust. It's saying it's got to be held in a trust. So, for example, if you look 3 lines up from the end, it says all investments made by the company as trustee shall be so designated.
Yes.
So to the extent that there's some loose language there in a fiduciary capacity, you have to read it in its context. And this is a late entrance, so we don't have any case law on this, but I'd be amazed. I'd be amazed if this is sort of cuts through. I mean, is that the suggestion? This cuts through the distinction in Hong Kong law between fiduciaries and trustees, and says no trust company can operate as a fiduciary other than as a trustee.
Well, it may do. I've no idea. Not an expert in Hong Kong law.
Well, no, but it's. I think if my learned friend wanted to make that case, he'd have to assert it, and then he'd have to support it. He needs to show you a good arguable case. Because think about what the effect of that is. He's effectively saying, well, 89 cuts across clause 6. It's not possible to have a clause 6 because Hong Kong law demands that FTT cannot do what it's purported to do, which is receive money on its own account and hold it and then apply fiduciary duties to that.
Fiduciary capacity would then fall under 89.
But it's not.
What does fiduciary capacity add?
It adds that they have to act in good faith and they have to deal with it. It probably does bring implied obligations as to the character and the quality of what they have to do. But just going back to the clause section 89, the question, I suppose, I mean, one way to cut through it is to point out that it only applies to, quotes, trust companies.
Yes. FTT is registered as a trust company, isn't it?
But it's not holding this money on trust. So it's not a trust company in respect of this, unless that's the effect of clause 6. It's not, well, I mean, maybe my own friend wants to make submissions that somehow this means this cuts down the services that a company like FTT can offer. But that's quite a substantial submission, never raised before, and would have the effect of saying actually clause 6 doesn't work.
Yeah.
But that case isn't being advanced, as far as I understand, and certainly isn't being supported. And it doesn't flow from section 89. So it just comes down to clause 6. And that answers the question, whose money is the money in the reserves? And the answer is it's not Techteryx's, one way or another, because that's what clause 6 says. And what they've got then is contractual duties, some of which are fiduciary in nature. So, you know, for example, there are contractual restrictions on the way in which FTT is entitled to invest those monies, but those are contractual. And so the result is that when the money goes into the reserves, it's not Techteryx's. And one of the things that I wanted to refer your lordship to, if the new bundle has made its way to you.
So the money, so the money becomes FDT's money.
Yes.
Okay.
Well, that's the logic. That's the natural conclusion.
Yes.
Unless there's trust, unless the beneficial interest stays behind, then it's just a trust. Sorry, then it's just FTTs. It's not the holders. It's not Techteryx's. It's not that surprising. And indeed, it's completely consistent with the way that the Techteryx has presented itself to the world. Techteryx's public statements are to the effect that it does not have any interest in these funds. And one of the places you can see that is in the new bundle at page 87. If you look at Miss Yard,
Right,
Mr. Yard.
I'm going to go and try and find that.
Thank you.
To log in. So this has been filed with the court now.
Well, I assume it's been added to the bundle because we've been asking for that to happen for some time. And my own friend confirmed that it would. They're in control of the bundle.
So what am I looking for and where should it be?
Bear with me. Thank you.
Yes.
Sorry.
Right. I've got a second supplementary hearing bundle, which was lodged today.
That's likely to be it.
Okay.
I apologise. My access for some reason is not working, but that may be a problem.
Further supplementary document.
Should be 90 odd pages, I think.
Well, it doesn't tell you on the court how many pages altogether.
I'm just crossing my fingers and hoping that the pagination matches the document that I'm looking at.
Okay.
I'm slightly nervous about time, so perhaps if I could give you the reference and then I'll just read it from the page. That.
Whatever you want. Yes.
Thank you. It's the second supplementary bundle, page 87. And you should find it in there. This is part of Mr. Thank you.
Okay.
It's I'll explain what it is. It's Mr. Yai's affidavit in the Hong Kong proceedings.
Okay.
In response to various allegations made again about the Glassdoor payments.
Yes.
And if you, one of the points that he makes, sorry, I'm told it's page 92. I don't know why the pagination is different, and can somebody?
It is. I mean, it does say section C, glass door on page 87. Is that what we want? What paragraph number are we after of this?
It's paragraph 39B.
Well, then, yes, then we'll be going down a little further. 39B is 92. Yeah.
Sorry about that.
That's right.
And one of the points that Mr. Yai is making is he introduces it earlier on, and he says that there's no arguable case. This is on page 86 and 91. He says, I understand TX now argues that the money paid by DMCC to Glassdoor belonged to TX because that money came from reserves, and explains why it couldn't. And one of the points that he makes is, if one looks at 39B, Techteryx confirms in their daily attestation reports that the TSD reserves are held by it for the benefit of TUSD holders, and it is not entitled to any funds at any time. In the true USD holdings report.
Sorry, where are you reading from?
39B, sorry.
Confirms
39B.
daily attestation reserves are held by them.
So this is he recites a statement made less than a month ago by the chief executive of Techteryx. So this is what they're saying in public. 2, the US denominated collateral held in accounts are the total balances in accounts held by Techteryx at a Hong Kong depository institution and Bahamian depository institutions for the benefit of the true USD token holders. 3, SAVE's already disclosed, Techteryx and the agents are not entitled to any funds at any time, and no amounts deposited into the accounts shall become the property of Techteryx. the agents, or any other entity, will be subject to any debts, liens, or encumbrances of any kind of Techteryx, the agents, or any other entity. Now you might say, well, it doesn't, how does that affect things? But A, Techteryx is telling the world that they have no interest in this property, in this fund, and yet they come to your court and say, well, just ignore all of that. Actually, we do have this interest. But B, I suppose this all turns on the terms on which that money was handed by Techteryx to FDT. And what this demonstrates is that Techteryx knows full well that the intention at that time was not to create a trust in its favor. They're telling you something different. So that's what I was going to say. Unless you got any other questions on the terms, the express trust part of it, I was going to come on and deal with firstly quis close and then constructive trusts briefly. Yeah. Quis close is brand new, said for the first time yesterday. It takes my learned friend no further because he cannot get past the terms of the agreement. He took you to the case in Bieber 2471 and in 2471 the paragraph.
Sorry, you're just running a bit
supplementary bundle. The
yes,
first
sorry,
one.
I'm just going to come out of bundle. Right, 2471.
Correct.
What? Yes, I have that.
And so he took you through some of this, but the question when you read these passages, the ultimate question is, what was the intention of the parties? Was it intended to leave the beneficial interest behind? So it's just another way of finding a trust in the terms of the agreement. And so paragraph 20 says, just at the beginning, such a trust is akin to a retention of title clause. Does your lordship see that?
Yes, I have that.
And then towards the end, about 2/3 of the way down, it says the recipient. The recipient has no beneficial interest in the money. Generally, the beneficial interest remains vested in the payer, subject only to the recipient's power to apply the money in accordance with the stated purpose. So that's what you would have to find in the terms of the agreement between the parties, an intention that that be the result. So 21, second sentence, if the properly construed terms upon which the payer and the recipient enter into an arrangement have the effect of creating a trust, then it is not necessary that either payer or recipient should intend to create a trust. It is sufficient that they intend to enter into the relevant agreement. So that's saying it's not subjective, it's objective. It's not subjective, it's objective. But what is the test? The test is whether objectively, on those terms, the intention is to create a trust. So it gets my learned friend no further. And if one wrap this up at the next page, 2472, paragraph 26. Over the page, 2472, paragraph 26. What is it at the heart of it? The nub of it, the money remains the property of the payer unless and until it is applied in accordance with his directions. So that's what the intention must be. The property remains with the paying party. So it gets my learned friend no further to say, well, quis close. The fact that there are restrictions on the use that can be made of the money is one factor which in certain circumstances can lead to a quis close analysis. but that's because it's a factor in those cases in determining that actually the ownership, the property, remains with the paying party until that is accomplished. So quis close doesn't help him. So what are the other fallbacks? First, he says, well, even if it was not a trust in a strict sense, it's sufficient for the claimant to establish a fiduciary relationship. What he's arguing, therefore, is that a fiduciary duty by itself can generate a trust. And so you can assert a constructive trust over the reserves as a result of breach of fiduciary duty in the way that they're used. So in other words, he's saying, right, start from the premise that the money belongs to FDT. If they breach their fiduciary duties, suddenly the money reverts to belonging to somebody else, in this case, to Techteryx. That is not, by the way, as with all of these points on constructive trust, none of this is pleaded in Hong Kong. So if one turns to the pleading in the main bundle, 751 recites the proprietary claims against the third and fourth defendants. And it all relies on the property, sorry, the reserves being the property of Techteryx in the first place. It's not actually advanced in this way. My learned friend's skeleton argument appears to suggest that there is some pleading in the reply to FDT's defence. So at page 32 of his skeleton, footnote 55 seems to be suggesting that some sort of claim to this effect is advanced, and he refers to paragraphs 4 to 35 of the reply to FDT's defence. So that wouldn't be a pleading against my client, but in any event, that pleading you will find at page 4468. And I will not take you through all of these paragraphs, I'm afraid, because he refers to paragraphs 4 to 35.
4468, sure?
No, I'm not sure. Sorry, it's a reference that's gone wrong. 4668.
Yep.
And he relies on paragraphs 5 to 55. But there is nothing in there. That is all, if you do have a chance to go through it, that is all about the express trust argument, about the terms of the agreements. There's no reference to constructive trust. There isn't even a reference to breach of fiduciary duty in that part of the pleading. But the argument fails anyway. The heart of the argument appears to be in my learned friend's skeleton arguments, paragraph 70.2, and this seemed to be where he was going.
Sorry,
Where
can you give me that reference again?
It's in his skeleton, claimant skeleton, page 29, paragraph 70.2. And what he says there is that breaches of trust are not confined to trusts in the strict sense, but extend also to property, which is subject to a fiduciary relationship. And he relies on Lewin, Agip Africa, and then this is the context in which he raises the Ricadzi case. So I'm going to go through those very briefly, if I may. And what was...
I just need to catch up with.
Yeah, of course.
Okay.
So the submission that I'm meeting is the one that breaches of trust are not confined to trusts in the strict sense, but extend also to property which is subject to a fiduciary relationship. And it's implicit in that you can end up with a trust over property which doesn't belong initially to the beneficiary. And the short answer, and I'll come on and explain why, is that a breach of fiduciary duty cannot give a principal to whom the duty is owed a proprietary interest in property which belongs to the fiduciary. That is 100% clear on the law. There is no doubt in the authorities on that. There's no argument about that. My learned friend presents it differently, but he's wrong. The Lewin passage we've already seen. Just to remind you, it's at supplementary bundle 1307. And I made the point that, yes, what there is reference there to a, quote, quasi-trustee, but it makes clear that a fiduciary obligation by itself is not enough because there is no property in which the principal has a proprietary interest. So it's saying you can have a situation where the fiduciary is not a trustee because they don't actually have custody of the property. And so where the cases are talking about quasi-trust situations, they're talking about situations where the fiduciary is not a custodian, non-custodian cases. So you don't strictly have a trust. But it says, as I point out in terms, that there needs to be a prior proprietary interest. It's not saying you can sort of magic up a proprietary interest out of a fiduciary duty. It's saying the opposite. The case that is referred to both there and by my learned friend Ajip, my learned friend took you to the first instance decision. I was going to take you to the Court of Appeal Authority, which is at page supplementary bundle 120. Just to a bit of it. I think that's where you were taken to, sorry. And that's Mr. Justice Millett's decision as he was. And just to frame the case, that was a case in which an employee had forged a payment order. And so the employee had caused his company's bank to pay money out to him, or sorry, to the defendant. The money went to somebody else. And you were shown the passage here, B, page 120B. The only restriction on the ability of equity to follow assets is the requirement that there must be some fiduciary relationship which permits the assistance of equity to be invoked. But the conclusion, you can see at F, you can see that this is all about the situation where it is the principal's money, the principal's property, which we're following. It's not authority for the suggestion that you don't need either a prior proprietary interest or a fiduciary duty. At F, it says there's clear authority that there is a receipt of trust property when a company's funds are misapplied by a director. And in my judgment, this is equally the case when a company's funds are misapplied by a person whose fiduciary position gave him control of them or enabled him to misapply them. So the point of that case was that he wasn't actually a trustee over the funds. He was just in a position to influence where they went. And so that's the sense.
In this case, you say that FDT may have been in a fiduciary position and may have had control of the funds, but they were not Techteryx's funds.
Correct.
Just counterfactual. So what happens if? So what would be Techteryx's remedy if it succeeds in its allegations in Hong Kong? You would say no proprietary remedy. It only has a remedy in damages.
Correct.
That wouldn't necessarily preclude a freezing injunction in the normal way. If the other criteria were satisfied, you'd have to be satisfied with the other criteria.
Yes, but there needs to be a good arguable case. And
yes.
A good arguable case needs to include a case for loss, which isn't dependent on a proprietary loss. So, in other words, what Techteryx is left with is a personal claim against FDT.
But it would have a claim for loss, wouldn't it? Because it wouldn't be able to pay the redemptions of the coin holder.
Well, that's not pleaded. That's not the case. Now, the answer is,
well, it said one of the affidavits, I forget which, says that this money is stopping them paying redemption.
well, the terms are on the basis, as I showed you, that actually there's no obligation to redeem in certain circumstances, and then the money is held at risk. So there is a question about whether or not the holders would actually have a claim against Techteryx at all. But assume that that's wrong, right? Next stage, what is Techteryx's claim? Well, Techteryx's claim is that FDT just needs to pay it back the money. Pay it back money. Not the money, but money. It has a contractual claim. So in other words, if they were completely right about this, what's the position? FDT has claims against Aria, Dmcc, and or the fund because it's FDT's money. But the answer would be that the claim by Techteryx would just be a contractual debt, well, presumably almost like a debt claim from FDT.
I see that. And what if they would succeed in misrep and conspiracy?
Well, again, it's what's their loss? What's their loss? My learned friend says that he doesn't have a rescission claim. That's pretty creative interpretation of what. But what's being sought to be rescinded as a result of misrep in Hong Kong is the SAA, the Strategic Alliance Agreement, by which they got their rights in relation to TrueCoin in the first place.
That's the other action.
So nobody is seeking to rescind the ESA.
No.
Or indeed any other agreement, as far as we can see, that is material to this issue. So what would they? The misrep claim would lead to damages. Come on, and if you want me to, I'll deal with that. Nobody's really looked at misrep. You don't really have any evidence on misrep, but we can look at where that gets them.
Well,
but my point is about
loss. It seems to me there is a pleaded case that the PPM promised essentially liquid short-term investments, and that didn't eventuate. I mean, that's what's pleaded.
Well, that we say,
and they were authorized, and the authorization they gave to FDT was to deploy the money. Trying to be neutral in the way that I phrase it. Deploy the money in relation to investment, which gave them a degree of liquidity.
I was going to come on and deal with my learned friend hasn't said anything to you, hasn't tried to impress on you at any stage the merits of those particular cases, right? And so I mean, I can deal with that, but there's a lot of other things to deal with as well. The short point that I was dealing with here was simply assume those cases are made out. What is the loss?
Yes.
And there is a claim against FTT. There's no suggestion that FTT is insolvent. So what is the loss? The position before was there's a contractual right to recover that amount of money from FTT. The position subsequently is there's a contractual right to recover that amount against FTT. So there's no pleaded allegation that, for example, FTT is insolvent. It's just left with contractual rights against FTT. There's no pleaded allegation that there's a queue of TrueCoin coin holders who are bringing claims against Techteryx. There's no pleaded allegation that Techteryx has dug into its own cash reserves to meet redemption requests. So, I mean, I'm hesitant to kind of embark on an analysis of the. I can do it if you want me to, but we're going to run out of time. The conspiracy claim and the misrep claim. But actually, when one looks at the misrep claim, the misrep is about the TrueCoin story. The claim. Well, I can take you to it.
There's a lot pleaded about the PPM. That's what concerns me.
I can come on to that. I'll come on to that. But where does it take us? It doesn't get them to a loss.
That's what I really want to know, because I mean I'm going to I will confine myself to what's in the pleading. But equally, then that means that what is in the pleading is up for discussion, and that there's more than just a very narrow claim as been addressed. We've got the pleadings in relation to misrep, in relation to conspiracy, in relation to the PPM, and that is concerning me.
All right. Well, look. Let me.
Also, the alternative. I'd like to know. And one of the issues is whether there's any more benefit in a proprietary injunction than there is in an ordinary freezing injunction, frankly.
Yeah. Well, I agree. I mean, on alternatives, and I was going to come back to this right at the end. I mean, we say, the claim has always been presented, and that's what we're meeting in a fairly tight time frame.
Yes.
A claim that is dependent on a proprietary interest. You've not heard any case put forward to you that the freezing order survives absent a proprietary interest. And if we want to have another hearing on that, and on another day when we line up with evidence to deal with that, we can do that. But for purposes of today, that's what you're confined to. Not because there's only a proprietary claim out there, but because that is where you find the loss. That is it. The misrep claim is not based on misrepresentations as to the use of the money. And I can show you this in due course. The misrep claim is based on what's called the so-called true coin story.
We can have
the true coins. Yeah. Can I do that in a moment, or can I? Do you want me
you
to
could do it anytime. No. I'm just giving you some sense as to my concerns. That's all. I've not come to any concluded view.
Of course,
these are just matters that are playing across my mind.
Of course. I think if I can just sort of soldier on a little bit, because I'm behind.
Yes, of course. Yes, of course.
And it's obviously most important to deal with the questions that you have. But the funders of fraud allegation is not a misrep allegation. Anyway, we'll come back to that. Tracing then at common law. So we were just in the Agip case, and the point I was making is there needs to be a prior proprietary interest to be traced, and you can see this in the Court of Appeal judgment at 143. And I'm going to take this at a bit of a clip because it may not be quite at the focus of what your lordship's thinking about, but tracing at common law, supplementary authorities bundle 143, and D, tracing at law does not depend upon the establishment of initial fiduciary relationship. That's the interesting thing about Agip. Liability depends upon receipt by the defendant of the plaintiff's money, right? And then E, identification in the defendant's hands of the plaintiff's asset is, however, necessary. It must be shown that the money received by the defendant was the money of the plaintiff. So my learned friend presents this to you as if this is an alternative case he can run in the absence of a proprietary claim, but it is not. Ricadzi, if we go to supplemental bundle page 505, should we call it recovery partners instead? Now, my learned friend refers to 3 paragraphs of this, but you can see what it's about from paragraph 2, which you'll find on page 510. I think, yes. And this is about the profit rule.
Yeah.
Paragraph 2, the equitable principle in issue on this appeal, put at the highest level of generality, is that the undertaking characteristic of a fiduciary relationship, that fiduciaries will act with single-minded loyalty towards their principals or beneficiaries, means that the fiduciary must account to the principal for any profits which the fiduciary makes from that fiduciary relationship, unless the principal has given its fully informed consent to the fiduciary keeping them for himself. It's about profits generated from the fiduciary duty, and it's because you can see the fiduciary has power over him, and you can see that down at 3. The profit rule originated as a duty owed by trustees to their beneficiaries, but it is equally applicable as between fiduciaries such as company directors and their companies. The directors are not trustees as such, because no trust property is vested in them, but they have powers and control over their principals' property and affairs, which they must exercise as fiduciaries. So there's 2 points there. One is you need a prior property of the principal, and the other is that the trust arises in respect of the profits only, not in respect of the fund. My learned friend took your lordship to a particular passage. I won't go through the whole judgment in light of everything that's been said, but if we go to page 536 of the bundle, this is my learned friend actually took you to the minority speech of Lord Legate, and that's not to diminish it, but there were slight subtle differences between the way that they treated the rule. The real issue on the case was whether or not there was a but-for causation test, and if the opportunity which arose was not in fact one which the principal could have exploited, does the fiduciary still have to account for the profits from that opportunity? But the passage here is actually quite instructive, paragraph 95, because Lord Legate says the fiduciary duty which references to the profit rule obscure is the duty of a trustee or other fiduciary not to use property or any information or opportunity which is to be treated as if it were property of the principal for the fiduciary's own benefit, or indeed for any purpose outside the scope of the fiduciary's authority, unless the principal has given its informed consent. So Lord Legate's making the point that the reason why it arises in a non-custodial way, even in relation to opportunities and information, is because you treat the opportunities and information as property of the principal. So again, there's no getting away from the need for a proprietary interest. But even if you do have a prior proprietary interest, it only applies to the profits, and we take that from Bousted 3265. But it's a logical consequence of the profit rule, because it applies to profits. 3265 of the same bundle. It's in the middle of the page. It is generally accepted, however, that it would be inappropriate for a breach of fiduciary duty to create proprietary rights in assets that have not been delivered. I'm so sorry. It should be 3265. 3265. It's an extract from Bousted.
3265. Okay.
Yes.
Yep, got it.
Thank you. And in the middle of the page, it is generally accepted, however, that it would be inappropriate for a breach of fiduciary duty to create proprietary rights in assets that have not been derived from the breach. Okay. So it's the profit rule. They've got to be derived from the breach. So if you start, as we say, you must, from the position that FTT owns the reserves, then no amount of fiduciary duties can get you to a constructive trust over the reserves. If there's a breach of fiduciary duty, you could only ever be over the profits that FTT earns from the breaches of fiduciary duty. But even that, we would say, doesn't work because it requires a prior proprietary interest. And the reason why Ricadze Recovery Partners works is because the information, the opportunity, is treated as the property. And then my learned friend says, well, you can just derive it from fraud, because there's fraud, full stop. Then there's a proprietary interest is generated. That's a very opaque way of putting it.
I think it's going to be international fraud as well.
Well, I know, and I mean he comes back to that subsequently. I mean that's an attempt we would suggest to say, you don't have to worry about good arguable case. You don't have to worry about these other factors. We've said fraud, and that's enough. So as long as we can make an arguable case there's been a fraud somewhere, give us our order. And we say that's totally unprincipled and not what the authorities say. But in this case, I think what he was saying was, well, if there's sort of fraud in relation to this fund, you can find a trust. But of course, you have to find it in his client's favour on this approach. So he took your lordship to the case of Rob, just to remind you of that. It's at 3584. And the relevant passage was at 3595. And the important bit was paragraph 44. Sorry, I'll start you at 43 if that's all right. It's 4 lines down. The overall consensus. The overall consensus.
We've read this.
Yeah. All right. But it's this bit, is that where a transaction is not void but is voidable for fraud, the fraudster acquires legal and beneficial title to the victim's property. And when the transaction is rescinded or set aside, but not before then, the equitable title to that property revests in the victim. So there's two possibilities. One is there's a transaction, money passed pursuant to a transaction which is void. The other is there's money passed pursuant to a transaction which is voidable and rescinded. But there's no other way. I
must say that English law is a complete mess on them.
Well, this is a statement from the late Chancellor, as he was then.
Yes, I know, and he feels that he's constrained by the authorities that he doesn't find particularly attractive.
Well, not in this particular way, though. I mean, the particular way that's being
asserted.
But
I mean, the idea that the fraudster actually gets full legal and beneficial title seems bizarre, actually, when one thinks about it.
Well, it depends on the nature of the fraud, right? So,
if it's a fraud, then you've tricked somebody out of something, and you're saying that you're rewarding the fraudster until the defrauded person discovers the fraud and avoids. I mean, it just seems wholly unjust. But there it is. It doesn't matter.
But it only really matters when the defrauded person finds out and says, well, that's my money. And it's that point that you ask the question, well, what happens next? And what the English law says is that actually the person who's the victim has a choice. And the victim can say, I actually quite like this contract, I'm going to continue with it and affirm it. Or they can say, no, all bets are off and it's going back to the beginning again. But one has to, it's a matter of logic. As a matter of logic, it's quite difficult just to say, well, because there's a fraud somewhere along the way, you unwind everything, because that just leaves chaos. But B, it's also an incident of a facility that's given to victims to say, well, now you've got a choice. You can choose the better line. If you think you're better off one way, then you go the other. But the bottom line is that, you know, in a case of just taking, if I just steal your money, I don't get good title. There's no transaction. If the transaction is void, I don't get good title. So there's no transaction there. But if I agree with you in a way that's misleading, and that gives you rights in relation to the contract, but doesn't render the contract void ab initio immediately, then you have to say, no, okay, I'm terminating this agreement. But just, my learned friend took you to Shalson, and I won't go back to it, but in that case, rescission was implied. So the statement, and of course, rescission can be implied.
Well,
but he
that's
says
the way around the hardship of the rule, I guess.
Well, you still have to make the choice, and you're still stuck if you decide that you want to. You can't hedge. You're still, well, you can hedge, but you need to be clear about it. But if you make a choice, you elect, then you can't go back on it. And he also took you to the case called Halley and the Law Society. And if you go through that case, that is a clear case where the contract was found to be void because it was just a mere instrument of fraud. So that's there's not, none of that challenges the dichotomy. Which have you got? Now, what he never did then was say, okay, well, here's the analysis of what actually we say gives rise to our proprietary right in this case. What contract is void? He just said, oh, well, we've got a pile of worthless contracts, but he never told us which ones he was talking about. Because in this case, it would have to be the contracts pursuant to which the money was advanced. Now, that gets quite complicated, and ultimately we would say there's no way of divorcing the ESA from the Strategic Alliance Agreement, which he says he hasn't rescinded. So, you know, just as I can't rescind a mortgage agreement but keep the loan, you know, if there's a single transaction, then, you know, I've got to make my election in relation to the whole of the transaction. And he says, well, I'm not rescinding the Strategic Alliance Agreement at all. Actually, it looks like he is in his pleading, but we can come back to that if needs be. But the point there is
the ESA would have to be avoided, is what you're saying.
The ESA would either have to be void or avoided.
Yeah.
And there's neither of those cases is advanced anywhere. Just, I mean, what there is there clearly is a rescission claim in relation to the SAA, not obviously pleaded against us.
No.
But it is pleaded. My learned friend said, "Oh, it's not in the plea, and we're only claiming damages." That's not accurate. But we can come back to that. And I don't think it really matters for now. It may matter more on full and frank, because the effect of a rescission of the SAA is they get nothing at all. And so if it's right, as we say it's right, that they tried in Hong Kong to argue and pursue a case to say the whole transaction, the whole purchase of TrueCoin needs to be set aside, that is something serious and material that should have been brought to your attention, because the consequence of that claim is they haven't got anything. But not only does Techteryx not seek to rescind the ESA, it relies on the terms of the ESA. So it alleges breaches of the ESA. So if you go to the main bundle at page 748, for example, (749). 748 sets out the alleged breaches of agreement. Sorry, it actually starts at 747. I do apologize. And so as against the first defendant, FDT, they set out breaches of the escrow services agreement and rely on that agreement all the way through those breaches. And then at 79, this is my point about loss. It's all couched in terms or predicated on a proprietary interest in the reserves, because 79, by reason of the matters aforesaid, the plaintiff has suffered loss and damage, being the difference in value between the present value of the escrow amount and the value which the escrow amount would have had if it had been properly invested. None of that matters if they've got contractual, unless that's theirs. So there's no, we say, avenue to a proprietary interest in the reserves, whether before or after any fiduciary duty or any fraud, and that is, we say, fatal to the claim. Now, where are we? It's 12:15. I am a little bit behind. I was going to come on to deal with some other issues. I was going to deal with the trust claim first and then come back to the other sorts of claims. I can bat on if you'd like me to, or if you'd like a break, we can stop. I'm very much in your hands.
Oh, well, let's have another 15 minutes, shall we?
Okay. Thank you. So 3:30, Dubai.
Yeah. Simon, let's carry on for another 15 minutes.
Oh, so sorry. I thought you said let's have
Sorry.
another break. I completely misheard you. So sorry.
No,
Breach of trust then. So I'll deal with these 2 points reasonably shortly, if I may. So the next issue would be breach of trust. So even if FDT was held on trust, if the payments were authorized, then there's no issue. However, we say the pleaded case in Hong Kong is that they were authorized. Now, if we go to 841 of the main bundle, this is the pleaded case against Mr. De Lorraine. And you were shown paragraph 44V. And paragraph 44R is the one that I wanted to show you. So the point is this, that my learned friend said, well, yeah, we do use the words Alex De Lorraine was authorized, but we clearly, I mean, the way he put it to you before was to say, well, actually, our case is that he was purportedly authorized, but that isn't actually the case. The case is that he was authorized, he had the authority, and he abused the authority.
Yes.
So 44R, they say, prior to the closing date, if you have that, the top line, prior to the closing date, the fourth and fifth defendants proposed, for purposes of business continuity, that the fifth defendant be appointed as an authorized person of the plaintiff to facilitate the orderly running of the business, and then to give instructions and directions to the operations team of the fourth defendant and to communicate with the investment and fiduciary partners of the business for all relevant purposes of the MSA. So he's authorized to communicate with them for all purposes. Such partners including the first defendant and the second defendant. So that includes FDT. In light of the experience of the fifth defendant, the plaintiff agreed to this request and the fifth defendant was appointed as authorized representative of the plaintiff, and all such actions were approved and ratified pursuant to a resolution of the plaintiff dated as of 8th of March 2021, but prepared some 8 months later after the date by FDT, the fourth defendant, the fifth defendant, and presented to the plaintiff for signing in or around November 2021. So what they are saying is he was authorized, and relying on his experience, we made a board resolution authorizing him. And we'll come back to that board resolution. But one of the points that I make to you, there is no plea of any sort suggesting that the board resolution was induced by misrepresentation by my client, or any misrepresentation that my client was aware of. My learned friends told you that at a prior hearing, but that is not in fact a case that's advanced. And then you've got 44V, without prejudice to the right of the plaintiff to identify and plead to other breaches by the fifth defendant, in breach of his fiduciary duty to the plaintiff, the fifth defendant authorized an aggregate 456 million of the additional investment sums, referred to in paragraph 25 above, to be remitted directly to Aria DMCC. So the claimant's case is that he actually had authority. Number one, he was in a position to give the authority, and he did give that authority for those payments to be made. That's the case. My own friend tries to spin it and say, oh, no, this is purported authority. We don't accept that he was authorized. But actually, that is precisely what is pleaded. Now, if we go to what my learned friend told you, we just pick this up at the ex parte, I think this was, yes. 1077. This is a skeleton argument. And you'll see paragraph 75. What he told you was the passages relied on in the parallel Hong Kong proceedings have been selectively quoted. In fact, A pleaded that means Techteryx pleaded, that Mr. De Lorraine purportedly authorised the additional investment sums in breach of his fiduciary duty to A, and that they were made without the knowledge, approval, or authorisation of A. The board resolution was drafted by First Digital Trust, Truecoin, and Mr. De Lorraine and presented to Techteryx in March 2022. And then says, insofar as A purportedly accepted First Digital Trust and Mr. Lorraine's purported investment of the additional invested sums in the fund, this was induced by fraudulent misrepresentation, including by Truecoin and Mr. De Lorraine, and then refers to Lee, paragraph 69J to L. And then they say further, in any event, Mr. De Lorraine's authority as specified and limited by the board resolution did not in any way extend to invest or making transfers to R1. But we just saw what was pleaded. What was pleaded was that he was authorised to make those transfers, and he was authorised, and then he authorised them.
Sorry, to make the transfers to DMCC.
Yeah. So
where'd you find that?
Sorry, 841. Sorry, maybe let's not do the paraphrasing thing because it's dangerous. Yeah, so he was 44R. He was authorised for all relevant purposes to communicate with the investment and fiduciary partners. That's 44R. He was appointed as authorised representative of the plaintiff by board resolution. And then 44V, without prejudice and blah, 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 in breach of his fiduciary duty, the fifth defendant authorised an aggregate 456 million of the additional investment sums to be remitted directly to Aria Dmcc. So
yes,
so
he authorised it, but was he authorised to authorise it? That's the point.
Well, that's what they plead. They say he was authorised.
Yes,
so
but not to invest in DMCC.
Well, but that's what they're saying in 44R.
The actual board, sorry, we didn't.
Well, I'll come to the board resolution in a moment, and that will be next. But if I can just take it in stages.
Yeah.
The first question is, what is that saying that he was purportedly authorised? That there was a purported board resolution, that there was a purported acceptance by the first respondent.
I accept all of that.
Yeah. Now, let me take you to the board resolution in a moment. But just to say, I mean, what Mr. De Lorraine relies on in Hong Kong is the board resolution and various Slack messages which he passed between him and Mr. Sun. I'll give you the reference to his evidence, but I won't take you there if that's all right for time. It's main bundle 7409, paragraph 711. But let's go straight. Sorry.
7409.
Paragraph 111.
Is De Lorraine's evidence.
De Lorraine, and he relies on the board resolution and the Slack messages. Yeah. And then the board resolution is at 565.
Okay, 565. Right, let's have a look at that.
And then there is resolution 3.1. With immediate, so it was resolved that the following persons be added as authorised persons with immediate effect to give instructions to FDT on behalf of the company, which include without limitation instructions in respect of the investment amounts and any other execution-based investment instructions relevant to CA, CSA or ESA, unless revoked by the board otherwise. So there's just general authorisation. He was authorised to give instructions. And then 3.3, further resolved that any actions and instructions given on behalf of the company to FDT in connection with the investment amount prior to the execution of these resolutions hereof be and are hereby ratified, confirmed, approved and adopted in all respects, as fully as if such actions and instructions have been presented to for approval and approved by the directors prior to such action being taken. So this is after the event, ratifying everything that's gone before. The pleading in Hong Kong is the board resolution was issued because we relied on Mr. De Lorraine's experience, and then he authorises the payment to DMCC. That's been ratified by 3.3. My learned friend told you, well, oh no, Miss Lee says that the board resolution was procured by fraud, but actually, when we go to Miss Lee's evidence, it doesn't say anything of the sort. And actually, so to suggest that the case was that there's a purported board resolution and a purported authorization actually just doesn't work. 3.7, then there's reference in particular to various payments and certificates and so forth to carry out the resolution referred to above. They're authorised in the name of the company to take such steps and do such things as they deem necessary, appropriate, desirable to give effect to the foregoing resolutions. Signing, making, executing, delivering to FDT and any other relevant persons, blah, blah, blah. Further resolved, need to do that one, probably not. Oh, sorry, what we missed out was 3.5, further resolved the form and substance of the enclosed investment proposal being hereby approved and adopted.
Let's have a look at that. Let's just
That's
follow
page 569, yes.
That's where we have the reference to Aria Commodity Finance Fund.
Yeah, so I think what you're looking for is the structured products and funds section, which is on page 569.
I have it in front of me now.
Yeah. Aria Commodity Finance Fund. So the proposal refers to Aria Commodities Finance Fund. So that's 3.5.
Yes.
No, that's right. Well, 2 points on that. Number one, if it ends up with the fund, if that is what happens in the end, then that is a ratified investment, and what happens along the way, even if you could say that that was some sort of breach, what's the difference? What's the loss, etc. As long as it ends up where it's supposed to go. This ratifies an investment in in the fund. That's the first point. Sorry, this approves an investment in the fund. The second point is that 3.3, as I showed you, ratified everything that's gone before. What about actually what happened on the ground at the time? 7326, we've got Slack messages, and this is the other thing that Mr. De Lorraine relied on.
Yes.
And this is a really troubling area because the Slack messages are messages that are being relayed from Mr. Justin's son. So 7326, you've got a lady called Maria.
Yeah.
And you'll see a request in the middle of the page from Mr. Alex De Lorraine, about 2/3 of the way down. We'd love to invest. We've got this money. And the response, I think that's cool. Let's do it. Do you have it confirmed today? And then over the page, 7327. Sorry, do you? And I think it means need. Do you need it confirmed today? And then over the page, 7327. Hey, I got Justin's approval. Please go ahead. Thanks. 7328. There's further requests being made of Mr. Justin's son. So in the box.
7328.
So next page.
Yeah, got it.
Good morning, Maria. I've got a question for you and I guess Justin. At the moment, we're investing so on. This is an allocation of another 200 million of the Aria funds for 6%. But if I were to shift money from, let's say, Prime Trust over, then we would have about 38% of the money invested. What do you think? Too risky, and so forth. And then says, I did want to ask you if you and Justin are comfortable of going a little higher while we can. Answer hi, yes. I think I am, and he will be too, but let me confirm with him. Thank you. And then over the page, asking some questions about it all. And then if we go down to 7335, there's quite a lot of exchange, and I don't need to take you through it all. You see towards the bottom of the page, Justin has 2 questions for the investment. Is it risky? What kind is this investment? 2, how much should we keep for the customer to mint redemption? Then we can decide if 38% is okay. You would like some data. And then over the page, there's some information provided.
Let's see what he says.
Aria is triple insured. They're basically funds that deal with trade finance organizations like the WHO or countries. We're just extending the amount we have with them. We can get out within 90 days, and we have staggered the past investments to allow flexibility. On average, we only need 15% in cash. We're super conservative and keep above 70% for the moment. Hope that helps.
So none of that represents the reality, then, does it? First of all, the investments in Aria, associated entities are not insured, and it's illiquid. Can't get out in 90 days. Rightly or wrongly, I mean, that's I mean, I don't mean this in any pejorative sense, but that's a misrepresentation of the investment.
That might be right, but nobody's saying that Aria, DMCC, Mr. Britain, or anybody associated with the funds told him to say that.
No, we get that from the PPM.
Well, but none of that's pleaded as being a basis on which the approval and ratification that came and that I've shown you as being pleaded out is relied on for the purposes of the board resolution. What's relied on for the purpose of the board resolution is Mr. Delorain's experience. Thank you. And it's not right. And the resolution comes after these messages, but it's not right that the PPM promises liquid investment. It leaves the discretion open to entirely to the fund manager.
There's a discretion there. Well, it's a matter of I guess interpretation of the PPM, but we can look at that.
I think the way you'd have to interpret it seems to me, because the PPM does not. At best, you would interpret it as a statement of present intention, and so you'd have to analyse it out as saying, well, all right, the PPM includes an implied representation that the intention is to invest funds. At the moment, the intention is to invest funds in liquid investments. That implied representation was false because X, Y, and Z, and that implied representation was communicated and relied on by the investor, and that vitiates the consent. So you need it to be analysed in those terms. Yes. But none of that is put forward as being the basis on which the claim is advanced.
Well, we'll look at the pleading in due course.
Yeah, but if you go down,
it's 33 minutes past.
Thank you.
Otherwise, we'll miss. So shall we again? Shall we take a relatively short break and come back at 3:40, or sorry, that's 12:40 for you, isn't it?
Yes, thank you.
Yeah. Okay, thank you very much. When you're ready.
Thank you. Very good. All right. Sorry, we were just on page 7336, I think. 7336. Yes, 7336. And the Slack message that I just wanted to show you was right at the second from last on that page. He approved. So just pausing there. We say that it is abundantly clear that you are simply being lied to about the involvement of Mr. Justice's son in Techteryx.
Justin.
I'm sorry?
Justin. I think you said justice, didn't you? Justin.
Did I say justice? Yeah, all right. Apologies for that. Maria Gu, so you know who this is the head of operations at Tron DAO.
Which is his company.
You can see that from page 7338, and that is one of Mr. Justin's son's company, which you see at 6742. And so he is giving instructions on behalf of Techteryx in these communications through.
It certainly looks like he's involved in some way, yes.
Well, he's approving the investments. He looks like he's more than involved. He's controlling the investments. He's also, as you know, I think, made frequent public statements on behalf of the claimant. So he's telling the world or one thing, and they are telling you something different. You have that at 5622 to 5630, and you may recall reference to a bounty that he has put up for recovery of these sums. He also, you may recall, showed up at the first return date, disguised as Bob. The slightly Baldric approach to the whole thing, but it would be funny if it wasn't so serious. But it is quite serious. And before he was ejected, he was asked some questions about who he was, and he gave highly misleading answers.
Quite. Oh yes, I wasn't massively impressed.
Well, the transcript's at 1291 and runs through to 1296, and you can see how he behaved. And Ms. Lee just blandly states, that she is in fact the beneficial owner of Techteryx. That's at 4767, paragraph 27. But in my submission, she doesn't deal with any of these ancillary points. Doesn't seek to explain why Mr. Justice Sum was invited by Techteryx, nominally her company, to a private hearing. She just says, no, it's mine. Full stop. Don't ask me any more questions. Which is pure assertion and unsupported by anything. So in our submission, there is a very strong case that you are being lied to about who is the ultimate beneficial owner of this company. And that it will be one of the things you need to decide. Is it right that this court should lend its considerable powers to a company that is saying one thing to the public? We've got no interest in these funds, but is telling you something completely different, or these funds are ours, and is also, we say, lying to you about, very clearly, about Mr. Justice Sum and his involvement. But for now, the point we would suggest is that the assertion by my learned friend at the ex parte hearing that Mr. de Lorraine was on a frolic of his own, which is how it was put by my learned friend, was simply false. And he weren't showing these messages. Frolic of his own appears at bundle references 1125. Yes, it was expressed authorization by Mr. Sum. And of course, there's the board resolution, which we've been through. So I'll come back to the fund as a fraud allegation in a minute. But ultimately, the upshot is FDT has invested the reserves in the fund. It was authorized to do so from the plain documents and from the plain case. And it's maybe serves Techteryx's purpose to say in this court that it has an interest in those reserves and those investments were unauthorized. But you will not be blind to the fact that it says in other courts completely different things. And I'll show you what it says to other courts in other countries about what has happened to this. So it makes, for example, a derivative claim through FDT's interest in the fund in one forum, and in another forum applies to get information about the fund because FDT is undoubtedly the shareholder. I'll deal with that in a moment. But it is a troubling feature of this litigation, which has never been addressed. It's just waved away, but it is important, we say. So in relation to the in the FDT case, sorry, in the case against my clients in Hong Kong, the board resolution is referred to by FDT, and they make this point: we were authorized to do all of this, and there is a bare denial of those passages in the reply. So I can show you that if you like, but there's no assertion that the resolution was induced by fraud or by a misrepresentation, which has been particularized in any way. So Your Honour's concern that, well, could it be said that perhaps statements in the PPM were relied on by Techteryx in giving its authorization? That is not a case that is advanced anywhere. And I'll take you back to the pleadings in a moment about what is advance, but it's safe to say that is the position. And of course, that's a rolled up factual allegation as well. It's not just about what's said in the PPM. It's about what, as a matter of fact, Techteryx relied on when they issued that board resolution. And unless they can say, well, we looked at the PPM, we took from that an implied representation that there was an intention to invest these in liquid funds, and that's actually what we took away with it as a matter of fact, and we relied on that as a matter of fact, then there's no even beginning to a case on that front. And they don't say any of those things. What they say is we did the board resolution because of the experience of Mr. Deloraine. I mentioned that you were told by my learned friend that the board resolution was induced by fraud. He relied on Ms. Lee's evidence in particular in her first affidavit, and he referred to paragraph 69J to L. I showed you that in his skeleton argument, but just to remind you of the reference, it's 1077 paragraph 75. You'll find it there. That was what was positioned at the ex parte. If you go to page 66 of the bundle, you will see what Ms. Lee actually said, and it wasn't that. So 66, this is the passage that was referred to by my learned friend, and it's J to L that he relied on. This is what Ms. Lee actually told you at the last hearing, at the beginning, sorry, the first hearing. The additional investment sums, that's the money, those are the 6 payments, were not made with Techteryx's instructions, and the 6 remittances were made without the knowledge, approval, or authorization of Techteryx. The passages relied on in the parallel Hong Kong proceedings have been selectively quoted. Techteryx pleaded that Mr. Deloraine purportedly authorised the additional investment sums in breach of his fiduciary duty, and that they were made without the knowledge, approval, or authorisation of Techteryx. And then in making the 6 remittances and the additional investment sums without instructions from Techteryx and without the knowledge, approval, or authorisation of Techteryx, First Digital Trust did not act in good faith, and they've been grossly negligent and blah, blah, blah. Now, just pausing there, that says nothing about the board resolution, right? So it doesn't tell you anything about the subsequent ratification, for example, of everything that went before. B, in saying that the 6 remittances were made without the knowledge, approval, or authorization of Techteryx, that rules out a case that they gave authorization by relying on the PPM, for example, or anything that came from Aria. Because they didn't rely on anything. They said it happened without our authorization. Where is the room for the case that there was some sort of misleading in that? They say it was all made without their knowledge, approval, or authorization. And then further down,
I'm not sure that follows. He could have been generally authorized to invest in the fund, but not in DMCC. Right. I mean, particularly by the express wording in the investment proposal annexed to the the board minute. And there's a history to that investment proposal, isn't there? Because that emanated ultimately from Crossbridge.
Right. Well, fine. So it refers to the fund. You've got the points that as long as the money ends up with the fund. I take your point. But secondly, you've got the prior ratification of everything that came before. But what certainly, all right. If you think that my submission went too far, that it rules out the prospect of them relying on anything. A, it's not evidence that they looked at the PPM and said, well, these are liquid investments, or that they were told what it says in the PPM, or anything else. This is not evidence that the authority was induced by fraud generally.
No,
it's not evidence that the board resolutions.
Yeah.
It's not evidence that
I
the
was just
board
picking
reviews.
up. I was just picking up
Yeah.
on the logic of the
Yeah.
submission that you're making. That's all.
And I understand. So if you think I go too far on that. But what they do, please. There's another footnote, I think, in the skeleton argument that was referred to, and it may be that this is what my learned friend was getting at.
But can we?
Yes, 1077.
We're
Sorry.
still on page 66.
Yes.
If we carry on reading, then the 6 remittances were never received by Aria Commodity Fund. So there's an issue of fact about that. The only relationship between Aria DMCC and Aria Commodity Fund is the fact that Ms. Britton, sole shareholder of Aria DMC, is the wife of Mr. Britton, director of Aria DMCC, is sole shareholder, sole director. Again, I know Mr. Britton denies some of those offices. But Mr. de Lorraine's authority, this is the important bit, I think, in relation to the board resolution. Mr. de Lorraine's authority, as specified and limited by the board resolution, did not in any way extend to invest in or making transfers to Aria DMCC, being a company whose ultimate beneficial owner was the spouse of Mr. Britton. The board resolution in no manner authorised or ratified that conduct by Mr. de Lorraine. So that's what's pleaded, rightly or wrongly.
But this is the evidence. This isn't the pleading.
Oh, sorry, this is the evidence. Sorry, forgive me. Yes,
I mean, yeah. I'll show you the pleading in a moment. I'll show you the pleading in a moment.
You're right. This is Ms. Lee's witness statement.
Yeah. Yes. This and particularly the bit in that purple box is what was referred to by my learned friend as supporting the submission that the board resolution was vitiated by fraud, that it was procured by misrepresentation.
Sorry, purple box.
Oh, you may not have one. I've got one. It's paragraphs J. It's paragraphs J to L. It may be that somebody else has marked up my bundle for me.
Somebody's marked up your bundle. I have a clean copy. Yes. Thank you.
Sorry about that.
That's right. Okay. Sorry. Do carry on.
Yeah. So the footnote also referred to paragraph 75 of the amended statement of claim in Hong Kong, which you will find at page 746.
Paragraph 75.
Yes, it was. The reference was to paragraphs 75 to 76.
Yeah.
So the paragraph in the skeleton argument, which mentioned these, was paragraph 75
as well. Yes.
It was 75 as well. And then there's a footnote to that, which is footnote 26, and that refers to these two.
Yes.
And then this is where you get to the misrep allegations. Paragraph 75, induced by and in reliance on the TrueCoin story, including the representations made at the relevant time, the plaintiff agreed to, and the representations, by the way, I'll show you, but those are representations of the TrueCoin story. The plaintiff agreed to and or accepted FGTs and Mr. Lorraine's purported investment of the additional investment sums in the fund. So the pleading is not, we looked at the PPM or anyone told us what that was. The pleading is we thought the TrueCoin story was accurate. And the TrueCoin story is nothing to do with this part of it. So the true.
So just before we go to that, 75.2 actually references that Slack message, doesn't it?
Oh, it does. You're right. Yeah. Thank you. That was the last of the additional investment sums.
Yeah, so that's the 200.
I mean, but that's a particular given of the inducement and reliance in relation to the quote's true coin story, including the capital representations.
So let's have a look at the true, what's included and not included in the true coin story.
All right, very good. True coin story is at page 761. And there are, I'm afraid, 23 different statements in there. And your Honour will need to read them, I guess, at some point. But none of them are alleged to have been made by the first respondent or indeed by Mr. Britton. These are all about the true coin story being that there's a dollar to token backing.
Yes.
So you can, I won't go through it.
Okay, I'm just scrolling through it.
Yeah. There's post-acquisition is 22, I suppose, but it refers to the Slack messages about insurance. But the true coin story is defined. None of them are said to have been made by or induced by or with the benefit of the first respondent or Mr. Britton. And then if you go to the pleading as to how it's introduced, you'll see it at paragraph 743. Now, it might be worth starting before that, just to show you the structure of the document. Because it's, if we start at 738, you can see how it all fits together. So the defendant's fraud and conspiracy, and you get the sort of soup of allegations. Because the allegation that the fund is a fraud is an allegation that is raised in the relation to the taking of the money, not in relation to the representation claim. So 63 is the fund as a fraud, and you get the particulars in relation to all of that.
But the plaintiff has since discovered that the fund is not in fact a genuine fund, that it never made genuine investments. But even if there were any real investments, they were invested in a way which is contrary to that envisaged in the PPM and the fund fact sheet. So
yeah,
yes, it's a bit of a farrago there, isn't it?
Yeah, but it's an allegation of sham in relation to the fund, and you can see how it develops. So paragraph 60. So you go down with this particular pleading. It's quite long, and then you get further at 64 and still further at 65. So these are sort of additional allegations that are lobbed in to say, well, this is all a fraud. And then 66 is where you get the punchline for all of that, which is on page 742, which says the 6 remittances to Aria Dmcc were blatant misappropriation and money laundering.
Yeah.
So that's all saying it's fraudulent taking. There's no case of inducement or anything like that. So obviously that's all derivative on there being a proprietary interest, because you have to take it from someone, and it's the person from whom it's taken. And then the closest I suppose you get is 67. Which is really intended to be a summary of the bits above. In short, the fund was at all material times a fraud and perpetrating a fraud. And then it goes on to say, and any story or representation about investing in the fund as a fund, which makes genuine investments to generate returns, was also fraudulent, but doesn't go on to say that there was kind of inducement at any point. So it doesn't actually it doesn't even plead a story or representation. It says any story or representation, but in any event, it goes on and says, paragraph 68. Indeed, the true coin story. The true coin story
and the representations.
Yeah.
What are the representation?
Yeah, the representations are above. Sorry, I had the reference sent to me and I've lost it now, so I'm going to write it down again. 725.
725.
So paragraph 26, the defendants told the true coin story as a continuing representation on numerous occasions to the public and to the plaintiff. Now that's alleged against the defendants, but there's
Plaintiff compound list of numerous occasions. Told the true coin story. A represent so the representations don't relate to the investment, they relate to the true coin story.
correct. And while it's alleged that the quotes defendants all told the true coin story, as I say, there's none of them in there which suggests that that story was told by any of the respondents to this application, by the respondent to this application, by my client. So where were we? We were at, I think, 7.
Sorry, just look at 26.
Yeah.
Yes, sorry, do carry on.
So we were down at page 742, just to pick that up, because we were looking at what were representations, and then 68 is where it said the true coin story and the representations were at all material times false, and then you have particulars of that.
So that's moved on from the fund.
Yeah. So that, yeah, exactly. So it's effectively two distinct parts. One is the fund as a fraud, but that is put as a fraudulent taking, and so it's predicated on Techteryx having a proprietary interest in the reserves, and then it moves on to, and there's a misrep claim,
But
and here
then
it is.
68.
Yeah.
The particulars under 68 are not directed towards the true coin story and the representations. So if you look at the particulars,
Yeah.
the investments are 97 million, quarterly invested. So thereafter, it's an additional 468 quarterly kept invested in the fund, the amount of almost the entirety of reserves. Investments in the fund were not and could not have been characterized as or as in cash and equivalent assets. From the fund's case,
yeah,
invested in essentially illiquid, risky, non-principal protected assets.
Yeah. So just to, sorry to not to cut you short, but the purpose of that those set of allegations is to demonstrate that the true coin story was false. So the true coin story was, you know, whatever, there'll always be cash available in reserves. So for example, so the true coin story was we keep it in cash and equivalents. So you have at 3 investments in the fund were not cash and equivalents. It's all allegations going to the falsity of the true coin story and the quotes representations. So actually, there's no allegation against the first respondent, particularized at least, that it's made any representation that has been relied on in any way. And then you go on in the pleading. So if your lordship goes down to paragraph 70, there's this pleading that the defendants all knew and were part of it. And paragraph 70 asserts that each of the other defendants must have known and in fact did know that the fund was a fraud and perpetrating fraud on the public. Oops. and on the plaintiff, and that any story or representation about investing in the fund as a fund, which makes genuine investments to generate returns, was also fraudulent. So but it's not actually, this is about knowledge. There's no assertion. And all the defense must have known and did know that the true coin story was in fact false. So you've got that, and the particulars which follow. Sorry, paragraph 72 then says, well, paragraph 71 says nothing against DMCC. Paragraph 72 then says, Truecoin, Legacy Trust, FDT, Crossbridge, Finneport, and the fund acted together in fraud to injure.
Not,
So that's the
not
conspiracy
a claim against the MCC, it's a claim against the fund.
Correct. And again, I mean, there's no evidence that the first respondent was in any way involved in Techteryx's acquisition of the interest in Truecoin, which is what you know, or indeed made any of these representations that are relied on. And after that, it's just
the DMCC has been joined as a party to these proceedings.
Yes, because it said that DMCC received Techteryx's money. So it is pleaded that the money belongs to Techteryx and it went from FDT and was received, so knowing receipt effectively, by my client. But and it is right that the allegations of misrepresentation are technically, I think, sort of, made against my clients, because it says the defendants made the representations, but then the particulars don't identify any representation by my claim. Oh, so it's only a proprietary claim. Sorry, it's only a proprietary claim. There's no personal knowing receipt claim against DMCC. So that is a proprietary claim.
Proprietary claims against third and fourth defendants.
And then, yeah, and that's all there is, other than the misrep claim or the deceit claim, effectively, on the one hand, and then the conspiracy claim on the other. So just to finish off with the misrep claim.
I'm just having a look at the claim for relief. Sorry, you are third defendant.
Yeah.
Are you third or fourth? Sorry, I can't remember. I have to go back up to the top of the document.
Sorry, DMCC is the fourth.
You're
the
fourth.
Fund
Okay.
the fund is the third.
Is the third. Okay, well, let's have a look at the claim for relief against the fourth. Declaration of fourth defendant holds as all material times an aggregate blah blah blah, inquires to which assets, an account as constructed trustee, an injunction. So there's no claim for damages.
Sorry, I've lost the page.
Sorry, I'm on page.
No, I've got it 758. Yeah, I've got that. Yeah, thank you.
There's no
I think well, I think it follows. So if you go down to 759, it says as against all defendants.
Okay, damages. Okay, so there's a roll up.
Damages, yeah, there is a rolled up. But one has to look back as to whether there is a substantive, properly pleaded fraud claim.
Yeah, that obviously that. Yeah. No, I'm just looking at the relief. That's all.
Yeah, so there is relief sought.
So there is a claim for damages. Okay, thank you.
But not at all. But if one goes back up just to finish the story in relation to this, to page, I think it's 746.
Mm-hmm.
And you'll see paragraph 74 and 75.
Mm-hmm.
Firstly, you've got the plaintiff's injury and loss, and then it says induced and buying in reliance on the true coin story, including the representations. The plaintiff did various things. And then that is the representation, or that is the set of representations which are also relied on in relation to the investment. So further induced by and in reliance on the true coin story, including the representations, the plaintiff agreed to and or accepted FDT and Mr. Lorraine's purported investment of the additional investment sums in the fund. So, and then says, didn't know about the payments to DMCC. So it's the true coin story all the way when it comes to this aspect of the claim. And the losses are at paragraph 76. And they've caused the plaintiff substantial losses because they've lost the value of the additional investment sums. But again, we say the loss is predicated on their ownership of those reserves, because otherwise they need to plead out a claim as to why their rights against FDT are impaired. So FDT, according to them, is obliged to meet TrueCoin holders' redemption claims for their potentially they're obliged to replenish the fund or the reserve account. But it doesn't, I mean, that's just an accounting entry for FDT. There is a conspiracy claim in there as well.
Yes.
I think we've been over a little bit of this, but your lordship will know you need 4 bits to that. One is the combination or agreement. Then you need an intention to injure. You need means, usually unlawful, sometimes lawful. There's a bit of controversy about that, but that's not the issue in this one. And then you need loss. And when you look at 741, it's sort of, it fails in limine because you never get the pleaded allegation against my client. So 741 is at paragraph 65. Uh, 65.1 alleges that various people knew each other. It's not an allegation of a combination. 65.2 talks about a business relationship, but isn't aimed at the first respondent or Mr. Britton. But none of that is a pleaded allegation of a combination in any event. And then if one goes down to 744, I think this is the bit we've already seen. Paragraph, sorry, 44 at the top, we saw that, and this is really the intention to injure, the acting in concert, the acting together in fraud and to injure. So that's really the crux of the conspiracy claim, and it's not advanced against R1. Now, within the particulars of that, there are 2 references to Mr. Britton, but they're not advanced as allegations against R1 as being party to the conspiracy. They are 9 and 18, which are at the bottom of page 744. Yes. Which is just the way they documented the investment was slapdash. And then 18, page 746 at the top, even after the fund defaulted on the plaintiff's redemptions, FDT, Finneport, Mr. Chock and Mr. I continued to side with the fund and Mr. Britton. So that's an allegation against them, not Mr. Britton. I suppose it's alleged as, in a sense, some sort of factual basis for an inference that they had an agreement, but that agreement's not pleaded. So what you end up with is the case that the fund is a fraud that's advanced on the basis of a claim for fraudulent taking and therefore predicated on a proprietary claim. And when the pleading says, well, they didn't follow the PPI, that's actually pleaded in support of the fund as a fraud claim, not in support of any misrep claim. Not against DMCC, that is. Well, it's not. I mean, misrep claims not really advanced against anyone because anyone on against the fund either, because it's not alleged that the fund actually made any representations, or at least there's no particularized allegation of a representation made by the fund. Knowledge. That was the next area. To have a tracing claim, to continue to be impressed with a trust, my client R1, the first respondent, DMCC, would need to know, firstly, that the money was held on trust, and secondly, that it was being applied in breach of trust. Why? Because otherwise it would be a bona fide purchaser for value. Obviously, there needs to be some value. If an innocent recipient of funds just is given somebody else's money, they don't give anything back, then the trust, the beneficial interest can follow. But that's not a scenario that's really factually going to arise in this case, in my submission. What's essential then is that there is some case as to how my clients became aware of these two facts. And my learned friend says, well, my client must have known they were investors because my client must have known they were investors because of the name of FTT. There's trust in the name. We say that's just a specious argument.
Well, he relies on the reference of TrueCoin and custody account as well, doesn't it?
Well, there's two parts to this. So one is, did they know that it was money that was being vested, actually, that it was held on trust for a third party? That's the first one. And the second part is, did we know that it was being applied in breach of that trust?
Yeah.
So we need both of them.
But with regard to the first part, I mean, if I'm entirely frank, at this stage, obviously Mr. Britton's a very sophisticated financial professional in dealing with trust companies. You can see references to TrueCoin, you can see references to the custody account. I should have thought that at the very least, that would have called for a KYC investigation into the source of the funds, and so he may well have been aware of the circumstances that the money was TrueCoin's money in an escrow account held by a trust. That only goes to the first part.
All right. I mean, I'm not going to.
I'm just dealing with this on a tribal issue basis. I'm not dealing with. I'm not making a finding.
I understand that. I think what I would suggest, though, is the better way to come at it is to ask, what is the case on knowledge?
Yes.
And where is the evidence to support that case? Okay. Because I think there's a risk with all these sorts of with fraud claims generally. That there is a risk that once one comes at it from the lens, there's a fraud here, that one starts to interpret everything as in a way that gives support to that, and that's a well-known phenomenon. And the where that becomes
bias, I think it's called.
Yeah, well, particularly in the context of fraud claims, though, because I think the authorities talk about it, looking at things through the lens of fraud. And where it becomes most acute is where parties are saying, well, we're going to make an inference because we don't have any information. And so there's a sort of lack of evidence becomes a supporting allegation. And that's a large part of my client's case, my opponent's case, and a large part of what I'll have to deal with subsequently. So it is important actually to say, all right, are we going to infer, are we going to allege that there's direct evidence, that there's direct, we know for a fact that they knew? You know, in other words, is there evidence that they were told, number one, or is there evidence on the basis of which I'm going to make an inference? And that is really what Your Honour is getting at, that essentially there may be primary facts on the basis of which it's safe to infer that there was the requisite amount of knowledge. And so the primary facts you've identified are Mr. Britton's sophisticated, very sort of very it's called FTT. There's a custody. There's a reference to TrueCoin in some of the subscription documentation. But what's essential, what the authorities say over and over again, is that one has to set out those facts and then look at which ones are pleaded and proved, and then determine, you know, right, what survives after that process, and then putting those together, do you get to an allegation of fraud? What's striking is that while there are a number of places in the Hong Kong pleadings which allege knowledge against the first respondent, none of them allege that the first respondent knew that the claimant had a proprietary interest in the reserves. And Your Lordship says, well, I think I would urge Your Lordship to approach this with an open mind, just because, I'm sure you will, but I mean in a neutral way, because I mean I showed Your Honour the bit from the claimant's own public statements that they have no interest in the reserves, and in those circumstances, one would have to know about the terms on which those monies were held in an escrow account and understand the intricacies of that. And is it safe to infer in the circumstances that that must just have been the case in this situation? Because that is the test when you're dealing with fraud. Are the other primary facts only consistent with fraud? Or are the primary facts, do they necessarily drive you to the conclusion that this was a fraudulent undertaking? And this is part of the allegation of fraud. So you may need to put it all in a piece with other bits of this claim, but ultimately we say start with the pleading, look at what's proved, and then you can decide, is that an arguable basis for fraud? So we're still in the pleadings, so I can do this relatively quickly, I think, I hope. So 744, I showed you. And 744 is the conspiracy allegation, but again, I mean, so I'm just pointing you to bits of the case which do allege knowledge against various people. That is not aimed at the first respondent.
We've looked at that. We've looked at 9, and we've looked at 18.
Thank you. And so 751, paragraph 88, I think, was the one that my learned friend directed you to. But this is the proprietary claim against the third and fourth defendants at 86 to 88. And you'll see at 86, there's a bare allegation of receipt in breach of trust. And then 88, there's an allegation that in receiving the 6 remittances, the first respondent was not acting in good faith. And what is said there is, second half of that paragraph, the fourth defendant via Mr. Britton knew or should be taken to have known that sums invested which were transferred to it by the third defendant, or which were directed by the third defendant to be paid directly to it, were being used otherwise and then in accordance with the terms of the PPM. That's where we get the allegation about the PPM. it's in the proprietary claim, but it doesn't support an allegation of knowledge. And it cannot logically sustain a plea of constructive trust on receipt, even when one gets to breach, because it's about what happened after were being used. So critically, we say there's no allegation that Mr. Britton or the first respondent knew that the sums paid to FDT were subject to a trust in favour of the claimant. And so we say on that ground alone, the constructive trusteeship claim the trustee claim in paragraph 89. Oh, they do say constructive trust, so I slightly misspoke earlier about that. But it's all on the basis of, it's not on the basis of the one that we've talked about. It's on the basis of a constructive trust flowing from the removal of their property from FTT in an unauthorized way. It's not a constructive trust arising in the other ways that we were discussing. But that's not supported by any allegation of knowledge of this being trust property. And then we've got the evidence, which is the board resolution and the Slack messages. So evidence about breach. And there's no real response to the resolution. There would need to be a case, for example, that the first respondent knew through Mr. Britton or otherwise that the board resolution was induced by misrepresentation, but that isn't even advanced. So there's not a lot in my own friend's skeleton, nothing in his evidence about any of this. This, I think, was partly what he pejoratively referred to as my pleading points. And, you know, I'll be blunt. I don't much care, and this court shouldn't much care who pleaded that claim. The question is, what is pleaded, and does it support the claim? And the answer is no. And it's not, as my learned friend said, me saying there's no allegation of fraud in there. One can see the word fraud throughout that. The question is actually, what are the particulars that underlie that? An allegation of fraud is never enough as a headline. So at the first stage, there's no plead allegation. The second stage, really they'd have to get around that board resolution in my submission. And there's no way, there's no basis to say the reserves were impressed with a trust without that when they were received by the first respondent. And of course, the FDT did receive, firstly, loan notes, trade finance notes in relation to, from DMCC, and we'll come on to deal with how that ended up being ported, but ultimately ended up with shares in the fund. Now, I'll come on to those aspects of the complaints that are made against me, but ultimately, and I know that the claimant disputes that there is a valid share register. It's not obvious that they continue to dispute that the FDT has shares in the fund, because that is a conclusion which would need to be drawn from a whole series of different. So, for example, they say, well, we're not convinced that we've got the full register, or we're not convinced about the porting exercise. But what's their actual case on whether or not FDT has received shares? Now, if one looks at the other things that they're saying to other courts around the world, they are saying FDT is a shareholder, 100%. And we can see that very shortly. If I can take you, please, to page 2381. This is the first affirmation of Ms. Lee in September 2023.
Sorry, this is a corrupted document. I have to
I see.
open another version.
I had the same problem actually, but multiple downloads seem to solve it.
Yeah, I don't know. I don't know how you download some parts from the court website. Sorry, bear with me.
Not at all. So it's 2381 was the.
Well, I have, I think, an uncorrupted version. Now 2381. Yes, it is uncorrupted. Yep, I have that.
Thank you. So this is Ms. Lee's affirmation in an application to appoint an inspector in relation to the fund. And this is what she said.
It's in Cayman, yes, isn't it?
In Cayman, yeah. So it's paragraph 10.
Yeah.
FDT, and then together it's affiliate legacy, currently has a combined total balance of 501,850,000 received from Techteryx's TUSD platform, invested in Aria Commodity Finance Fund. The invested funds is further particularised below. As explained in more detail at paragraph 50 below, based on NAV statements and so forth, shareholding in ACFF, as at the time of signing this affirmation, is estimated to account for approximately 97% of ACFF's shares.
And so then, cutting it. I mean, it's late, and I think I don't want you to press on with something that I know the answer to. You're going to submit to me that they had to assert that they were shareholders for the purpose of this inspection application in Cayman. It stayed because there is something in the articles, I think, which prohibits a winding up by a shareholder or inspection by a shareholder in any event. But they are telling the Cayman court that they're shareholders. That's your point, isn't it?
They're telling the Cayman court that FDT is a shareholder.
Yes,
that's the other case. That's what you're referring to is another case, which is a statutory demand.
Oh, so that's a stat demand. Okay.
This one was settled.
Okay.
On terms, I think, that subject to an NDA, documents were produced. Oh, sorry, vacated. It was vacated. I don't think it was settled.
But the point is that they assert. I mean,
yeah,
they assert that they were shareholders.
Yeah.
The case was unsettled.
Not they.
Well, I mean, yes, FDT. I mean FDT was shareholders.
Yeah,
yes.
Correct. And the other references are 2397, paragraph 50.1. Ms. Lee says it's obviously clear that in return for the funds they received, FDT and Legacy received shares. And then at 50.4, she says, there is no doubt, 50.4 is on page 2399. Final sentence, I believe there is no doubt that FDT is the registered shareholder of significantly more than 20% of the total outstanding and issued non-management shares, share of the fund.
That presumably is a statutory minimum to claim the relief that they're claiming.
Exactly. So paragraph 51, FDT holds shares. I mean, it's just replete with allegations to that effect. And just pausing there, if that case is right, what rights could Techteryx have? What claim could Techteryx have? They have a claim against FDT for negligence or whatever it may be in relation to the investment of the funds. But FDT holds its interest in the funds. Any dispute about what goes on at the fund level is between the fund and its shareholders. What's the response to this? And I think this is really important, and it's just something that just gets brushed aside. And this is a discretionary remedy that's being sought here. It's an equitable remedy, and there are multiple applications being sought in multiple different places, allegations of fraud being spewed all over the place. And Ms. Lee, on whose sole evidence Techteryx relies, in addition to documents and all the rest, goes to the Cayman courts and says, I've got no doubt whatsoever that FTT is a shareholder. And then she advances a different opposite case to you. And her response to that is pretty outrageous, we would say, which is simply, she just says, well, this overlooks the fact that FDT needed to assert a shareholding qualification to bring those proceedings under Cayman law. That's at bundle 1685, paragraph 14. So she just said, I said it because I had to say. This is what you're dealing with. She gave evidence to a court, not because it was true, but because it was expedient for her to give that evidence. Then you've got the statutory demand, and this is the other one, and I know it's late, and I don't want to drag this out any longer than it has to. But 4740 is where it is. If you'll just indulge me for a few more minutes, I can just get through this bit, and then we're on to funds.
Okay, sorry, page?
4740. This is even more extraordinary because this document was filed after these proceedings were commenced. So this isn't sort of, nobody can say that there was something new came up. And when we made this statement, we didn't know what we know in Dubai. $47.40 is a statutory demand, and you'll see the heading. It's issued by Techteryx. And you'll see from the name, do you see the name section there? It says Techteryx derivatively and in the name of its trustee and fiduciary, First Digital Trust Limited. So it's claiming through FDT, and it's signed by, yes, Ms. Lee. It claims $200 million. And then you see the particulars of the debt 2 pages later, 4742. And if you read 2 to 7, they're relying on the investments and the redemption rights. And that's after the freezing order was issued. And it's totally inconsistent with Techteryx having a proprietary interest in money in the hands of my clients.
I need to read them. I won't read it now.
So if FDT owns the terms, that's incompatible with an allegation that Techteryx owns the cash. It's just completely and utterly opposite and contradictory. They were restrained on ex parte basis, no, well, on an interim basis from presenting that statutory demand. I think on the basis of, as you say, a dispute resolution clause. But they're not in a hurry to get the return date on, it appears. But so it's a live proceedings. It's not stayed as such. But there is an ongoing case in which they're saying something completely the opposite to another court. And your lordship I will invite your lordship to consider whether you should just say, in those sorts of circumstances, I'm just going to wash my hands of a lot of this. Because that's unacceptable.
Temptation. So you say they don't have clean hands?
I beg your pardon?
You say they don't have clean hands? No.
And it's not just the Mr. Justice son is and they're lying to you about his involvement. It's that they're saying completely contradictory things in an unequivocal way. It's not, here's our primary case, here's our secondary case. It's no. There's absolutely no doubt that FDT is a shareholder.
Approbating and reprobating.
Someone would call it that. And then I'm told that there is also a similar receipt. Oh yes, it's the receivership. There's a receivership application in Hong Kong as well. And that is at page 7214. And if you go into page 7216, which identifies the assets of FTT over which a receivership is being sought, and then they say, well, and that is said to extend to the money, quotes, invested by the first defendant into the third defendant out of the escrow account. Again, filed after these proceedings. So I do say that there is an issue about what is being alleged here, both on the pleadings, on the evidence that you're faced with, and consistency with other jurisdictions. And we say it's not just it's very beguiling to say all we need is a good, a real prospect of success. All you need is a barely arguable claim, because one does have to assess the value of that claim. And I think your lordship accepted that in one of your judgments, interim judgments along the way. In this case, it's the Hoffman Films Rover point. The worse the interference is, the more serious you need to be, the more careful you need to be, the more sure you need to be that this is a really serious claim. And we say just it doesn't get over the threshold purely on the proprietary interest point alone. We say it doesn't get over the threshold on breach, particularly because of the board resolution and the way that it's pleaded. Doesn't get over the threshold on knowledge. But all of these points added together show that this is at the highest a highly speculative claim at this level. And I'll come on to the funders of fraud bits, because all of this is distinct from the funders of fraud. All of this comes before and prior to the funders of fraud. We don't want you to leave here thinking we're just taking technical points. We don't have answers. We've tried to assemble in the time we've got the answers to the concerns that are raised, the complaints that are raised, and we now know who the Kroll report came from and Mr. Bruno Arbois and his supposed independence. But we're not posing to undertake an audit here of the fund. We do say that those are fitted up allegations, ex post facto allegations, designed and derived from a conclusion, which is that this is a fraudulent endeavour, and then pasting that conclusion onto every piece of evidence that comes their way. But so we don't want you to be uneasy about that, to the extent that we can give you comfort. But this is not a strong claim. And my learned friend says, "Oh, there's no chance. You can find there's no good arguable case." This is really speculative, we say. So I'll leave it there for today. I think your lordship's probably had enough of me anyway. I think. Well, that's nice to hear, but untrue, I'm sure. We will. I do say that I'll talk to my learned friend. But I do say you will probably be hearing from me for the most of the morning, and then a little bit from Mr. McPherson. So tomorrow after lunch.
Yes, I mean, so far, if it's helpful, I should have thought that some of the points on non-disclosure have fallen away when you look at the transcript.
All right, take that on board. We will discuss it overnight and fully understood. I think what the premise of the argument, though, was that if there's a dispute of fact, it can't give rise to a full and frank point, and that is not accurate.
No, but I mean, it was clear that we did discuss certain things that it said were not disclosed. I mean, And
All right.
I think you should. I think you should review.
We
the
will.
Position.
Thank you. Understood. Understood. We will. But yeah. All right. Very good.
Okay. In which case, we'll.
Can I just check that I gave you the correct reference to the document that we were looking at there? Because I may have said 7126, but I hope you were looking at 7216.
7216. I've got 7216.
Oh, good. I was told maybe I made the wrong.
No. I've got 7216 in my note.
Okay. Thank you very much.
Okay. Well, we'll adjourn until 10 a.m. tomorrow morning. In that case, thank you very much.
Thank you. Tom, do you want a quick word?